Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dahil hindi Anglican, please, verbal slap.
Hello.
Is that correct?
I didn't ask you to interrupt me.
That's literally not true.
Oh, for crumb's sake.
Good morning, happy Friday. It's No Pants Friday, but I'm not showing you my feet. Sorry. You can ask all you want, it's not going to happen. Welcome. Welcome. It is good to be here. Let's get some lights on the desk so we can see what we're doing. All right. Oh. Good morning. Good morning, Regina Adams, first in chat this morning, and I think, let me turn the music down just a little bit so I can think. I think it's also your birthday, Regina. Is that a possibility? I'm thinking, yes. You won on your birthday, which is rare. It's extremely rare. It only happens, to some people once a year, at most. And now it's happened for you, so. Paula Mack says, I'm glad you acknowledged the holiday pictures on podcast. Acknowledged for what they were worth. You put me in flannel. Like lumberjack, full lumberjack. Regina, for your prize, I'm going to send you, I'm going to punish you. Everything IP-related worldwide is your responsibility on your birthday. On your birthday. Congratulations and welcome. I should play the lottery today. Clearly a sign. Let's see. Anyone else experiencing random delays on RA streams the past few days? Delay in starting? Yeah, weird. I don't know. Must be tech something. Not related to me. Are you talking about starting late or something else? If it's something else, I don't know what it is, but starting late is clearly not my problem. And I put you in flannel. They're like, he's clearly a lumberjack. We know what he wears on his off days. All right, let's see. He says, sorry, I parked in the fire lane. I will look at you while looking at me. I went, after the show last night, I realized I went on a little bit of a rant about people who park in the fire lane at the grocery store. Okay, like there's something special, and you know that extra 15 feet. I realize if you like are medically challenged and walking is difficult, and you're making it to the store, and that's your situation. You've got someone to drop you off at the door. Okay, I am not going to complain in the slightest about that. But if you pull up in your Lexus, okay, with their stereo thumping and your tinted windows, and you just park there real quick because hey, you want to grab a pack of I don't know, what is that crappy brand of cigarette? I don't know. I looked up online. Unfortunately, I know what the problem is. In North Carolina, I'm laying this right at the legislature's feet. The problem is we only charge a maximum of a $50 fine, 50, for parking in the fire lane. That's the most you can get. And most places charge less. It's basically, it's like a VIP parking fee, but most of the time you get away without paying. What the heck, legislature? If this is really a problem, put some teeth in the bill. Add a 0 or 2. Fix the problem. But no, $50. $50. Let's see. Marcianoka? Is it Marcianoka? Congratulations. This is awesome. 2-year sobriety today. That is great. Thank you for sharing that with us. That is wonderful. Congratulations. We're excited to see every day get added to that tally. That is awesome. Thanks. It's inspirational. Melissa says, I cannot believe I missed the podcast live. Well, you know when it was. Let's see. What if you're just getting a Mountain Dew? Phil? No. And you know how partial I am to that beverage, that heavenly beverage that you referenced, which I'm currently not drinking any of. Don't park in the fire lane. And if for some reason you've got, the stars have aligned and you have the one legit reason to actually park in the fire lane that is not, I am a fire truck, have the common courtesy to not block the entrance to the store at the same time. Good morning, Phil. Welcome. It's good to have you here. Oh, okay. I know. And Crazier Cat, this is wrong to admit, but thoughts went through my head about, wouldn't that be fun if the fire department had to come out here right now? I wonder what would have to happen for the fire department to have to respond right now and need that spot. Man, I'd like to see a fire hose running right through the passenger window and out the driver's door window on that car.
Don't put a diplomatic plate on a hoopty.
I'd love it if nobody got hurt and that happened. Yeah. Some thoughts passed through my head. They were dark thoughts. I did not act on them. Don't park in the fire lane. All right, handicap parking is just the same, although the problem's removed 15 feet from the fire lane. It's not a lesser offense. I think it's greater because more people need the handicapped parking spot than the fire lane. How many times, by a show of hands, how many of you have been like, I'm at the grocery store and look who's parked in the fire lane? It's the fire truck. Rarely, if ever, does that happen. Okay, I admit it's like a blue moon, right? When that happens. But you always have people who need the handicapped parking and need that little bit of help or need to be able to avoid the narrow parking spaces. They need extra space to get out of their car. They might need, to get their wheelchair out of their car, but maneuverability, or it might just be, for whatever reason, they have their placard. Don't be like, I'm cool enough. I'm just going to park here. Yeah. All right. We're supposed to be watching court today. We're supposed to be singing happy birthday to Regina and probably a couple other people. But I'm going to have to crack open, I don't know. Do we do the smoked Gouda or the smoky cheddar today? I'm gonna continue my snacking from last night. Maybe that'll help my mood a little bit. Smoky cheddar it is. Okay, we'll go with the Pringles. All right, we're going to celebrate birthdays. Thank you, Red Pen, for putting this together. Thank you to all our mods for making all this happen in the morning. It would not happen without you. Thank you. Happy birthday to Allie G, Hulkster, Michelle, and Regina. There might have been one other person. Who, Mrs. Ari back is feeling better. Yes, tons better. She slept well last night, and she decided not to do yoga this morning. I'm like, you did yoga yesterday? You're unable to move, and you're you did yoga? Now I know the problem. Okay. All right. Anyway, here we go. I got sidetracked. There might have been another person who's on the birthday list, but on the form, somebody posted, I don't know, their friend's Facebook URL, which did not come through. So if your name should be on the list, and it didn't work, Allie G, Hulkster, Michelle, Regina, obviously yours did. Let's see. Poe says my birthday's Sunday. Does that count? We can add Poe. Poe, of course. Anyway, let's see. Everyone, now that I've warmed up my voice with a little bit of frustration.
Happy birthday. You look good.
All right, here we go. All right. Wherever you are, stand up, take a breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. Here we go. We're going to sing happy birthday to Allie G, Hulkster, Michelle, Regina, and Poe. Or Poe and Regina. PR, yeah, there we go. Happy birthday to you. Happy birthday to you. Happy birthday, dear Allie G, Hulkster, Michelle, Poe, and Regina. Happy birthday to you. Happy birthday to Crazier Cat's son as well, who's in the Mayo Clinic. I'm not sure choice, patient or doctor? There are two ways to be there. Hopefully doctor. If it's a patient, it's a good place to be. 12 more who's celebrating their birthday today. Happy birthday. There are many wonderful days. Today is your special day. There are a million places you could have been and a million people you could have celebrated with, but you chose to be here with us. The privilege, the pleasure, the honor, the joy is ours. Hopefully we can return that joy back to you, make your day just a little more special, or begin to help yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's, Tanning, Dunlap's House, Andy's Grill, Bob Evans, and Cracker Barrel. I'm sorry. Hopefully, that's a good place to be, though. Great doctors. Great doctors. Hope he gets the best of care. Matt, happy birthday. Sorry. Happy birthday, Matt. I'm sorry you're in the hospital. Did we sing already? Did we sing to Matt? Do you want a verse for Matt? Crazier Cat? Should we do that? You have to answer quickly. Sing it. Happy birthday to you. Happy birthday to you. Happy birthday, dear Matt. Happy birthday to you. Who is Hat McClaw? Free hats. I don't know what that is. I don't know. I'm not sure if that's a real person. Sounds like something out of Dr. Seuss. It comes with a hashtag. All right. It's time for the drum solo finish. You can drum on this. I did the symbol on the. You saw that I did the thing. All right, Pringle's not a sponsor, by the way. Going with the smoky cheddar today. For Red Pen, I will be muting my mic while chewing. This is an improvement from podcast yesterday, and I apologize. Going back and listening, this mic is fantastic. It really picks up sound well. Red Pen, thank you. I'll try to eat them off camera. How about that? All right, it sure is. Yes, it was. We got the full ASMR effect and all the effects that you don't want on the podcast. It was a lot of fun. We have a couple things going on. Unfortunately, it is Friday. I mean, it's fortunate for us. Unfortunately, for people in courts that we like to watch, it is Friday because that means it's landlord-tenant day for a lot of courts. So Judge Middleton, Judge Simpson, some of the other regular places we pop in at. Remember, some of us use headphones. Earbuds could be worse. It just puts it right in your ear canals. Smoke the cheddar if you got them, says Crazier Cat for sure. So we've got a little bit of landlord-tenant court hopping, which is not my favorite. But, this is the big but. Next week, the fireworks start. Some of the good courts that we're looking at following are going to be happening. Phil, I'm so tempted. I think it might. I don't know. I think the Virginia court might deliver in a way that we can watch and it'd be okay. Let's see. We also have some some Louisiana parole board stuff going on. Let's go to Judge Middleton first, mostly because I miss him. I miss him already because he's not even gone yet, but one day he will be. So let's jump up there and see what.
No, they have not. They didn't in the last case either. So we'll see what's what.
We'll see.
If it's just an appearance, we should be fine with a 10:45 on the 23rd.
Okay.
Starts
I've
on
got
Monday, right, Phil?
two of these that they're extensive. The case just before yours has issues, and so does this one. It's a new year, 2026, a new crop of landlord-tenant cases to work through.
Your Honor, can I ask you a question?
Yes.
If she doesn't show up for my case, can I wait to talk to her?
Yes, we're going to, no matter what happens, we're going to adjourn this matter.
Okay.
Now, however, if Samantha Sprague doesn't show up, the other defendant Shandy Faulkner, she's subject to default. She's not late yet, but if she isn't here, they can get an order right now.
She said she would appear by Zoom. She did not want to come.
All right, well, if she has I don't blame you. I wouldn't want to come out in this cold morning either, but.
Well, the wind's about to blow you down.
Yes, it's 50 degrees, but the wind's blowing at 50 miles an hour. I'm hoping it'll blow all my leaves away.
Very windy.
And somebody else's yard.
Yeah.
Of course, somebody else's leaves then blow into my yard,
Yeah, they
so
go
that's
back and forth with the leaves.
not how it works. All right, it is 9:40.
We're going to jump really quickly. See what's up in Warren County. Same prosecutor as before, same judge as before. Big stretch from the judge. No prosecution, no defendant. Might be a minute.
I got a stubby little pencil.
Maybe Judge Buchanan real quick. Let's see how she's doing. We're going to jump around until we can find somebody. We'll keep our eyes peeled.
I and 22L2763632OI. These are tickets, Ms. Nagengast, you received back in 2022 for which you owe fines and costs. You were given time to pay, hard to even read it. Looks like March of 2025, Judge Simmons wrote that you were to give you 60 days to apply for disability and see how that's going. And then she said you didn't show up for your show cause hearing and you didn't pay, so you ended up with warrants. I guess at this point, are you wanting to set up a payment plan or?
Yes, Your Honor, if I can. And I've made once my disability payments came in, you know, it was hard playing catch up for 2-3 years worth of no income because I kept losing jobs due to my disability.
Sure.
And I have made a payment of $50 on each ticket. And they said that if I started making payments, that would make the warrants go away.
No, that's not how it works. Oh. Being here right now will make the warrants get canceled, but now I have to write a payment plan on these. So what do you propose? What can you afford?
It's okay. Can I do $75?
Is that affordable for you?
It would be tight, but I was living while I was on waiting for my disability. I was living on $35.29 old child support for my 38-year-old son. So I learned how to scrimp and save and deal with next to nothing.
Wow. How much does she owe?
But if Your Honor will allow, I can drop that down to 50 if that's okay. And that'll. Thank you.
Michelle's Mixed Media
When do
Madness.
you want that to start?
You are, in fact, an OG.
Can we do it at the beginning of February, before the 5th?
I will say smoked cheddar chips. They're good.
I can put it on that Friday the 6th. I mean, it doesn't have to be before the 5th.
But they're not amazing.
Okay, beginning February 6th?
Yeah, that sounds good.
Okay, so every month, by around the 6th of each month, $50 towards both files. So 50 total. I'm not saying 50 plus 50, but 50 total.
Thank you.
Payment plan.
This will clear the warrants that she has for her. They're Gouda, but they're not great. This is just smoked cheddar. I'll do the Gouda.
Cancel bench.
The Gouda, I went with the
Is it
cheese.
helpful to you if I give you a note that tells you to make your payment?
I will put it in my phone each month. I've got another payment from years ago and I'll just schedule that with that.
Okay, so you are good. You don't need another note.
Correct.
Okay, all right. So firstly, you're going to receive a letter regarding that doctor evaluation. You're going to work on making these payments, $50 by the 6th of each month. If you can't make your payment, it's important that you contact the court and ask for further extension so you don't get a bench warrant. Also, remember that you need to keep us up to date on your address, because if it changes and we get the doctor letter and we set a court date, you need to be able to receive that court date. If you miss your court date, you risk a bench warrant that way. So make sure you're keeping us up to date on your address. Also continue to follow your bond, including no contact with Miss Walkington. No direct contact, no indirect contact. Do not cause a third party to have contact. You're not to be within 2,000 feet of where she lives, works, or goes to school. If you violate that order, you risk arrest without a warrant, the bond being revoked and being in contempt of court. Contempt is punishable by 93 days in jail or $7,500 in fines. So continue to follow your bond until we can get all this sorted out, okay?
$7,500.
Anything else from the lawyers for Miss Nagengas?
No, she's good, but we're going to jump to 44th. 3, 2, 1, jump.
2 weeks out, correct?
Typically, I'm the one scheduling it. Yes.
Magistrate, if I can throw out there, it appears that she doesn't have any ongoing relations with Corwell. If there were to be something scheduled with Corwell, that she would have notice. So maybe if the court would consider a no contact for any non-essential purposes, with the thought if something needs to be scheduled, that they would petition the court for permission at that point. Obviously, barring any emergencies, of course.
This is not barring the mother. This is barring the daughter.
Barring.
We're going to get to the mother, her case, and we'll have appropriate terms. But this is, I'm only speaking on the daughter, and you don't have any reason to go to the hospital for your personal care, do you, ma'am?
Hopefully not.
Not unless there's an unforeseen emergency for myself or my children.
Okay. So
which I would not feel comfortable going there anyways.
Okay. Well, we're concerned right now, the court is, with your conduct at Corwell. Okay. So your commentary about Corwell is unnecessary and inappropriate during this hearing. So we're good. Ms. Powers, we're concentrating on you because you're the one before the court. So the request to adjourn the arraignment is denied. We're going to waive the formal reading based upon counsel's representations. I've confirmed the address and the phone number of the defendant on Victor Street in Roseville. The court is setting a $7,500 personal bond with the following conditions. You have to personally appear for any and all court appearances, any pre-trials, further exams, arraignment, trial, and or sentencing. You have to abide by any judgment entered in this case and surrender to serve any sentence imposed. You are not to leave the state of Michigan without permission of the court. Do not commit any crime while released. You shall immediately notify the court in writing of any change of address or telephone number. You are not to use alcohol, marijuana, or any other illegal controlled substance. Is this gentleman? You are not to possess or purchase a firearm or other dangerous weapon. You shall not assault, harass, intimidate, beat, wound, or threaten the 3 individuals and or employees of Corwell Hospital whose initials are JC, BH, and NR. Their full legal names will be set forth in the papers that you receive from the court and in your order for pretrial release. You shall not have or cause anyone to have contact with these 3 individuals at the hospital. You are not to enter upon Corwell premises on the Royal Oak campus, and that includes, that's all encompassing. If it's on that Royal Oak campus at 13 in Woodward, you are not to enter upon there. The bond is $7,500 personal bond. And we will set this matter for a pretrial. Defendant does not want assigned counsel, correct, ma'am?
Correct.
So counsel is not being assigned to you. We will set this matter for a pretrial. You have Judge K. The notice of the pretrial, the notice to appear will be sent to your home address. It will be up to you and your retained counsel to get all the necessary information for that court appearance. Because we don't have assigned counsel, you don't have an attorney linked to this case, so the court will not be sending out notice. There will be an order for fingerprints. And defendant must be fingerprinted within 7 days of today's date. Okay, and the notice to appear, and it'll be up to you to handle advising your attorney of that next hearing date and to have him or her appear on your behalf.
Now I want to know what happened at the hospital.
Okay, understood. Do we have that next date?
No, it gets set by the clerks. I don't control that. And it gets mailed to you to your home address. Okay? Is there anything further requested or required of the court on behalf of Ms. Powers' counsel?
Nothing further. Destiny, you'll know the date within a week. Just make sure your counsel know. They'll be able to follow up for the police report and everything else we discussed.
Okay. In the meantime, am I able to obtain discovery?
That you can speak to your counsel about that. They can make a formal petition as soon as the date is set.
As now pro per, can I request that?
You can contact the Royal Oak City Attorney's Office and make that request.
Understood.
Okay, Mr. Angot, here's a legal quagmire and Attorney Gagnon. Ms. Powers is the legal guardian of Miss Badarack. So do you want I don't know about her competency to speak with you, Mr. Angot, but we have a co-defendant issue here.
Judge, it's interesting you bring that up because I've just been quickly researching it. I'm not really comfortable with going forward on Miss Badarack's arraignment without her guardian present, but this is a very unique situation where her guardian is in fact the co-defendant. So
right.
What happened?
May I don't know where Miss Badarack is now. I'd like a little bit of time to see if I can get an answer to it. I've reached out to several attorneys as well to see if they've come up with this situation.
Okay. So I'm going to call the next case and there's no co-legal guardian, Ms. Powers?
No, there is not. And I was just going to ask if maybe I could be in a breakout room with Mr. Angot.
No, we have an issue here because you're a co-defendant. There's a conflict of interest. So Mr. Gagnon cannot handle your mother's arraignment. So we called in a different assigned counsel. So there's no conflict of interest. So we have a professional responsibility to make sure there's no conflict of interest. We keep everything clean as to the two co-defendants, because you may make statements against each other and then it's privileged and it gets very, very dirty quickly from a professional responsibility ethical standard. We're trying to uphold that. On top of the layer of that, there's an issue where you're the legal guardian for your mother and you're supposed to represent her in legal entanglements or her legal interests, but you're tainted because you're a co-defendant.
You got taint
and so
all over
normally if we just had a defendant with a legal guardian who is not also a co-defendant, you would be in that room. But you have certain constitutionally protected interests and rights that we need to protect, and the attorneys need to live, and the court needs to live by our professional responsibility. So what we're going to do is to make sure everyone's protected and represented. We're going to give Mr. Angot and the court a minute. Mr. Angot, these letters of guardianship expire on 2/18/26 or until further order of the court. So I'm going to look up the ROA. This is out of Monroe. and she was named as a temporary guardian. This was brought into the courtroom, but I'm going to look up the ROA and the guardianship case. And
might put this off until
when I
after
have
the
a break,
guardianship's
I'm going to
over.
take some other cases, and then I'll come back to you.
And Judge, just kind of thinking this through, it may require the court to appoint an interim guardian for this case, but I'll find out what I can find out.
Okay, right. I'm going to do the same. It's a little. Okay.
Thank you.
I'm not sure what happened, but these two got in trouble and are not allowed to go back to, what is it, Cromwell Hospital or something.
Sorry, everyone, that took a little bit longer. Mr. Provanzo, are you representing the Macomb County Jail person? I can't hear you, sir. Could you please unmute yourself, please?
Sorry about that.
That's okay. I'm just trying.
Yeah, Nunzio Provenzano, P39780, on behalf of Miss Grace Corker. And I need to see the the prosecutor.
Okay, I don't know if you're in the right court. I don't have prosecutors.
Not.
This is for arraignments.
Oh, yeah, no, I'm on a pre-trial and...
you're in the wrong place. Who's your judge?
I believe it's Judge Meineke.
Okay, that's 305.
Okay, hold on one second.
You're in the wrong Zoom. You're in the magistrate's courtroom.
Yep, okay, I noticed. Okay, 305.
They probably put out a show cause for you, sir.
516.
516.
0819.
0819. Thank you.
Thank you.
He gone. Wrong Zoom. Oops. It's like my lawyer said he'd be
Judge,
there.
Yes.
Do you have for a breakout room?
Who would you like a breakout room with?
You?
Oh, sure. Let's go to room.
Oh, sure. Judge, can I meet with you?
2.
Thank you.
Not on any particular case. Oh, it did her dirty on the pause game. Look. Okay. All right. That was funny. Interesting legal conundrum there where you've got a daughter who is the legal guardian for her mother, who has the legal right to represent her in legal matters, like her mother getting in trouble for some sort of behavior at the hospital. Imagine it was some sort of disturbance or angry about something. And then you add to that the daughter was also there and also got in the same trouble. So they're both facing the same charges. And now you have a conflict of interest where she's representing someone else who is a co-defendant. You could have a situation where she throws the co-defendant under the bus to protect herself, right? That would be a conflict of interest where I have the authority to make statements or admit guilt and say it was all me for my mother, but I was not involved. So, yeah, crazy. Let's see what else we have. We just, she's still here. Let's see if we have any other.
What?
I'm trying to avoid
Destiny's in jail.
Landlord tenant if I can help it. Let's see, who is this? Judge Clark?
So what's that?
You should not form any definite or fixed opinion on the merits of the case until you've heard all the evidence, the argument of the lawyers, and the instructions on the law that I give to you.
At the beginning of the case, we
Until
might stick
that
with this
time,
one.
You should not discuss the case among yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. Jurors must decide the case without distraction and only on the evidence presented in the courtroom. Jurors must not conduct any investigation on their own.
Cachette,
this
thank you
includes
very
reading
much.
newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case, the people and places involved in this case. You may not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. If you investigate, research, or make inquiries on your own, I have no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. This is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity, our judicial system promises. You are also not permitted to communicate about this case with anyone, including your spouse, family members, friends, neighbors, and even your fellow jurors. No communication includes no in-person, telephonic, or electronic communication, such as emailing, text messaging, posting information on a social media or a website, or any other form of communication. If you would like to take notes during the trial, you may do so. On the other hand, of course, you're not required to take notes if you do not want to. That will be left up to you individually. You have been provided with a notepad and a pen for use if you wish to take notes. Any notes that you take will be for your own personal use. However, you should not take them with you from the courtroom. During recesses, the bailiff will take possession of your notes and will return them to you when we reconvene. After you completed your deliberations, the bailiff will deliver your notes to me. They will be destroyed. No one will ever read your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence and should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. During the trial, the court may take recesses and you will be permitted to separate and go about your personal affairs. It is important to remember that the prohibition on communicating about this case applies during these recesses, whether you're in the courthouse or elsewhere. If at any time you find yourself in a situation where others are discussing the case in your presence, leave that situation at once and immediately report the matter to the bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices, smartwatches, must be turned off while you're in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during recesses, but even then you may not use your cell phone or electronic device to find out any information about the case or to communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you're deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that will require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both.
We're in Florida, Panhandle of Florida here.
A defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made,
I'm going to mute him for just a second. We don't know anything about this case right now. It's literally jury instructions. We're watching from the get-go. It's a jury trial. Probably will be done in a couple hours at most. Some of these trials are very, very quick. Defendants in blue on the far right. Now the jury's seated sort of in the middle of the screen, just off the left of the picture on the right. But this is Judge Clark, and he's a no BS judge.
May be required, or how long it will last. When such conferences occur, they will be conducted to consume as little of your time as is necessary for a fair and orderly trial of the case. Mr. White, whenever you're ready.
Thank you, Your Honor. May it please the court, counsel. I asked you to stop. I begged you to stop. Those were the words that Ms. Connie Domingue said on the night of October 12th of 2024.
And be gone. Be gone.
On that in Clarkston or not. If he does, he should get a personal bond and he's HIDA eligible on it, but he does plan on taking care of this. He regretfully hasn't. So we'd ask for a personal bond on it.
Is the address on Perling Brook Street in Livonia a good address? I'm sorry, sir, I had to mute you because I just couldn't get through. Counsel, is that a good address?
I did not ask him his address.
Okay, so just for your future reference, the court always needs a new confirm the address and the phone number because that's where we send notices and call defendants. So as a matter of course, that will always be asked and requested in any arraignments. Now I can't unmute him. Did you get a phone number for him, ma'am?
No.
Okay, we're going to recall, we're holding the arraignment on the bench warrant. We're going to recall and set aside the bench warrant. The total amount due and owing is $461. The court is setting a $461 personal bond. No money's due at this time. We're going to set this for a show cause hearing. The notice to appear will be sent to the Livonia address. Sir, upon your release, though, you may, yes, ma'am, I didn't mean to cut you off. You have something to say?
Yeah, I apologize. He's unmuted now. If you
Oh, okay. Sir, can I have your phone?
248.
8675309.
3.
Yes, that's correct.
Okay, thank you. So upon release on this matter, please call our court, ask for the collections department, either pay off the debt in full so you and I don't have to meet again or make a payment arrangement. If you don't do that, the court's going to set this matter for a show cause. You better show up or you and I are going to meet again. Okay? It's plain and simple. Make a payment plan, be responsible, pay your debts, make a plan you can live by it, close the file, please. Okay? Anything further requested or required of the court on behalf of this gentleman, counsel?
No, Your Honor.
Okay, thank you so much. Yes, sir.
I have one question. I get paid on Thursday. Would it be, do I have to like set it up this weekend or can I just
the court posted a personal bond. So you don't have to post any money. You've cleared the warrant on this case. Okay. The next step is I'm instructing you to please call the collections department and make a payment on the debt or pay it in full or make a payment plan with them. Be honest with them as to what you can afford. Live by the agreement until you pay it off and close the file. If you don't do that, I put in the ROA that they're going to set this matter for a show cause hearing.
Is Maxwell
You're
in the fire
going
truck?
to get a notice to appear to your Livonia address. It'll have a date and time for you to Zoom on, and they're going to say, why haven't you paid this debt yet? How much can you pay now? And they're going to hopefully set up a payment plan at the show cause hearing. If you just bury your head in the sand and you don't show up for the show cause hearing, you will get another bench warrant issued. And you and I, there's a chance that you and I or another magistrate of this court, we will meet again. So you don't have to post any money. You don't have to post any money now upon your release. I'm just asking you to be responsible, call the court, set up a payment plan and pay as much as you can. Okay?
Okay.
Is that clear?
Yes.
Okay. Do you have any other questions of the court or anything further that I could do for you, sir?
Not that I'm aware of, no.
Okay. How about counsel? Anything further requested or required of the court on behalf of this gentleman, ma'am?
No, Your Honor.
Okay. Thank you. You may both leave the Zoom. Happy New Year.
Thank you.
I think Maxwell's a fireman. That's got to be his fire truck.
I have a trooper here. I have a trooper here.
Is Maxwell the
Where,
trooper?
where did my trooper go? Who's anyone? Oh, okay. OCJ, you can leave. So I'm going to remove you from the Zoom.
Bye, OCJ.
And you're good to go. Okay, sir? Now,
A little
you
update on
have
what just happened on the
Mr.
Clark
Gagnon, you
case.
have someone in the breakout room,
I
right?
saw the signs that
Correct. The Macomb County Jail. We're
it was
ready
a,
on.
Okay, we're
10,
moving that.
it was an
Yeah,
SA
we're moving
case.
that.
Your
Not gonna
10:30,
go
we'd
there.
be ready.
To involve
I saw
children
the
or
trooper
something.
coming.
We're
Where'd he go?
just not going to do that.
Yeah, Koki was here. Okay, the name of the OCJ person. Who's an OCJ? The 10 Bezel?
Jacob Beasel, correct?
Okay. Thank you. Was he able to go to the main session? Yes. I like
He's
how
he's present right now on the screen.
Macomb County Jail, whatever they have, they can manipulate the rooms, whereas OCJ cannot. Okay, are you ready, counsel?
We are. Thank you.
Okay, calling the case of 2501798. This is the state of Michigan versus Jacob Bezel or Bezel. Your appearances, please.
Thank you. Good morning. For the record, Patrick Gagnon. I'm here as the Raymond only attorney on behalf of Mr. Beasel. Jacob, if you could state your name for the court.
Jacob Beasel.
Thank you for that. He is present, so the record's clear by video from the Macomb County Jail. No objection handling this matter by video this morning. Did speak in private to Mr. Beasel just now. Reviewed with him the 2 felony charges. Mr. Beasel, you understand what you're charged with, is that correct?
Yes.
Given his acknowledgement, I'd ask the court to waive any further reading. He would request a not guilty plea to be entered on his behalf. Given his location in the jail, he is going to request appointed counsel. I would just make a request if the clerk's office for the court could submit that form on his behalf, just so that he would have counsel available next Friday.
Okay, 1 second. Tell me again about the form so I can put it in the ROA for you.
Just the standard court-appointed form needs to be sent to the county.
Okay.
I imagine the court can sign on his behalf. Currently, he's unemployed. There's no income, but his contact information listed with the court that is valid for him.
Okay, so if he's not in custody, the Northwind Drive in Fraser is a good address for you, sir?
Yes.
Okay, thank you.
He enunciates quite clearly.
Okay, and what do you have to say about bond and bond conditions? Will he
My understanding that he's been in Macomb County now since August. He does have a sentence date coming up later this month on the 20th. He indicated in all likelihood he's going to be released after the 20th. There's no other hold speaking to him, no other open cases with the exception of this case. I mentioned to him the fact that the court issues a personal bond that he's not going to receive credit for the remaining balance. He's going to be in custody, but I would make that request. I don't think he's in a position to post any money. My understanding that he did attempt to contact the court earlier. Obviously, he was able to set this court date up, but this is something that he has been trying to address. So I don't get the indication from him that he's going to ignore the case. So if you would consider with any conditions appropriate, I would ask the monetary amount to be set at a personal bond, please.
Okay, 1 moment, please. I need to review the file.
Okay, you say a secret, so.
Mr. Maxwell is leading the yoga class today. I thought he was stretching. He's going to burst a button if he's not careful. Yep. A couple new positions I haven't seen before. Just tighten that trap. Just get that arm real far back there. Feel it tight across the chest. If it doesn't feel tight across the chest, you're doing it wrong. Gossip, rumor, and innuendo. Kathy, welcome. How are you doing? I think you're right. Somebody called this. I think Maxwell is in the back of a converted school bus, which I think is his home. I think he lives in a bus. How far away did he say? Well, it's distant. He just, I'm ruining it. Why is the room red? Where is that? That is the back door to the school bus. Or, oh, yeah. The biceps. He did the full power. That was bad things happened there.
Bailey.
What would the name of the bus be? Name that bus. Got overhead channel lighting down the center. It's a choice.
Body all set.
It's Clifford, the big red bus. I saw the Shaggin' Wagon. That always is a possibility, but not very original. Straight from Dumb and Dumber, right? No, maybe that's a different movie. Others saying it's a fire bus. It's a bus. It's a bus. That's not. That is a rear exit door that used to have a window that now has like plastic bolted in place. Stash says fireman. Yeah. The fireman growing a mustache and a beard is basically just a flex, saying, look how close to fire I can get without singeing my beard. That's why they do it. What is he charged with? Bad taste in paint? No. It's going to be something else. We're going to stick around for it, see what it is, though. He might be next. He has been flexing. Come on back. Sure he's not in the back of one of those white kidnapper vans. No, I think those have to be black on the inside by regulation. Kidnapper vans are all black on the inside. Looks a little bit like a Tom Selleck. That's where I think where he follows the inspiration for his mustache. Maybe you got a ticket for stealth camping. Ooh. Now we're going with the full shot.
Okay,
the
the court is setting the following bond conditions. Sir, you have to personally appear for any exam, arraignment, trial, and or sentencing.
Doing the tousled hair look.
Preliminary exams. You have to abide by any judgment, enter in this case, surrender to serve any sentence imposed. Do not leave the state of Michigan without permission of the court. Do not commit any crime while released. Immediately notify the court in writing of any change of address from Northwind. Or do we have a phone number? Is Northwind Drive a good address for you when you're not in custody?
Yes.
Okay.
Northwind is valid. I'll chat his phone number as soon as we're done.
Okay, thank you. You shall immediately notify the court in writing of any change of address or telephone number. You are not to use alcohol, marijuana, or any other illegal controlled substance. You shall drug test with pretrial services 5 times per month. I was reading the criminal history. Does he have, counsel, do you know if there's any restriction that he's to be equipped with a GPS tether upon release in any other case?
I'm going to venture to guess no. Just his statements to me that there's nothing else pending, unless, of course, he gets sentenced to that when he appears on the 20th.
Okay. You are not to possess a firearm or other dangerous weapon. You shall not go to Panda Express in Royal Oak. And you shall check supervision with pretrial services 1 time per week.
This is cruel and unusual. This is too much, Judge.
The bond is $10,000 cash surety.
What did he do with Panda Express?
Defendant must contact.
Get a $10K bond.
Pretrial services within 3 days of release.
He probably ate too many samples.
to set up testing and supervision.
Tried to sample everything. Or asked for 2 shrimp in a sample from the honey walnut shrimp dish.
We'll set this matter for a PCC, a probable cause conference. That will be no less than 7 days, no more than 14 days of today's date. We'll set this matter for a preliminary exam. And is there anything further requested or required of the court on behalf of Mr. Bezel?
Nothing further. Thank you.
Okay, yes, sir. Yes, sir. Did I miss something?
No, I've been waiting to get to release the treatment.
Okay, do you think that's going to happen in one of these cases?
Yes. I got a personal bond of treatment through Macomb County Circuit Court.
Okay. On the one you're getting sentenced on?
Yes.
So Patrick, that I guess the question is with the financial, I don't want the financial bond to interfere with that. Is that
He's
the issue?
he explained to me he's not able to post anything. So if the only way he would be released on this would be with a personal bond. The trade-off would be that he would not be receiving credit if he does remain in custody.
Okay. Could I word it where I would say if he's not released for treatment, then he has to post the bond. But if he is released, gives us an order for that, then that would suffice for the bond.
Well, what's going to happen is he's going to end up getting transferred to Oakland. I could say he could take it up with the assigned judge when he appears next Friday.
Is he supposed to be released for treatment before Friday, though?
Yes.
See, that's what I'm saying. It's not the court's position really to interfere with people getting treatment.
The only way to get around it would be issuing a personal bond here.
A personal bond with the condition upon getting the order for the treatment, correct?
I guess, but
bail.
then the court would be in a position to whether or not they could be able to confirm that. So
Heavenly Wood is calling.
I think you would just have to-
Heavenly Wood is calling. We're going to Judge Wolf.
in it and hit the gun safe that he has in there.
Okay. I guess was that bullet recovered?
Yes, sir.
Judge Wolf in the Heavenly Wood courtroom in Tennessee.
Was anybody injured?
No, sir.
Okay.
Getting testimony. Not sure if this is a trial or a hearing.
Did you have another incident occur with Mr. Ragsdale?
Yes, sir.
All right. Would that have been on in February of this year?
Yes, sir.
All right. What happened? Where did this incident happen?
It happened at Thunder Alley, the bowling alley.
Okay. And going back, your house, where is that located?
It is approximately 20 minutes from the bowling alley.
Okay. And that's where
Mr.
this.
Brooks, did I understand you to say it was February of this year?
Yes, sir.
But since February hasn't arrived in 2026.
I'm sorry. February 2025.
Did it happen in the
Thank you,
future?
Judge. My calendar hasn't switched yet.
We were time jumping or something.
Yes,
so.
sir. No, my internal calendar has not reset yet, apparently.
Got you, okay.
So February 2025.
I'm sorry. Look at this. Maxwell. I want to see Maxwell. We're going to jump back to Judge Wolf in just a minute. But Maxwell keeps flexing on my camera. And I'm jumping you guys around. I'm sorry. We've got to get closure on the bus, fire truck, converted camper, whatever it is. Little whiplash. We have to see Maxwell. He started flexing and he was doing the whole bit where he was feeling his biceps. And are we done with Macomb? If Maxwell could go next, and then we could jump down to Judge Wolf. That would be wonderful. Maxwell, I think it's time for another flex. Maybe challenge the guy in jail to a bicep flexing contest. Or you could just like compare tats. I mean, you do you, but I believe he is a defendant waiting for his moment, his primetime moment. That has got to be the back door on a school bus. You've got the curve of the roof going on. Judge. Be great if we could wrap this one up and just... Are we current on this, or did we go back? Let me check.
Okay, still staying on this gentleman's, Mr. Bezel's case. All right. So you think, Mr. Bezel, that you, in your Macomb County case, you're going to get an order to go to treatment?
Yes, I already have the order.
Okay, what kind of treatment is it and where?
It's a 90-day TRICAP Saginaw.
Okay. All right. So the bond is as stated. Where did I write that? And the bond will convert to a personal bond in that same amount upon entry into the treatment program. So if you don't enter, you have a cash bond that you have to post. But if you enter, it will convert to a personal bond.
They'll let
and
him
I cleared it with
go to treatment?
my court clerk, the judge's clerk, and our probation, our department, that can be done. So there will be no snafus on that. Okay, so the cash bond stands until such time as you actually enter the treatment program, at which time it will convert to a personal bond. Do you understand that?
Yes.
Yeah, because I want, the court always encourages you to go to treatment, okay?
Thank you.
Okay, so can you tell me the name of it in Saginaw, and say it slower because I'm not well versed, so I have to listen and write and learn at the same time. So go ahead, sir.
TRICAP.
TRICAP. And it's in Saginaw?
Yes.
Okay. So if you actually
don't think
enroll
it's
in that,
the
then
van.
your bond will convert to a personal bond. It was 10,000 cash surety, so it'll be convert to 1 second. I have someone helping me here, so 1 second.
We have somebody helping. Uh-oh, what's up? What's up, Maxwell? What are we doing? Glad he didn't get the memo about No Pants Friday. This could have been problematic at this point. That's got to be a bus door.
Okay, sir, you're going to be,
It's got the
sir, are
handle
you
there
going
and
to be
everything?
taken there directly right from release? Are you going to
Yes.
be transferred there? Okay.
Yes.
All right. So the cash bond will convert to a personal bond upon enrollment in the treatment program. Okay, is that clear? And we'll set this for a PCC, but that won't happen before Friday, right? Next Friday, the 16th, will it? Because the sentencing is the 20th.
Wait, what's that?
Is he still going to be in custody for the first?
He'll be in custody next Friday. Just make a request so the clerks know to order him from Macomb County.
Okay, thank you so much. This concludes the arraignment, sir.
Sounds good. Good luck to you, sir.
Okay, thank you.
Okay, now we're on to Maxwell, I think.
Mr. Angott, I haven't forgotten about you. What about you, please?
I know.
Now they go back into another breakout room. Use the remote, turn off the camera. Click, he gone. Maxwell's just chilling here. I think he's frozen. Or he's holding very, very still. I think we're playing statue. Nope. Mr. Angott? What kind of camera is it that pan, tilts, and zooms digitally like that? Is it just a zoom feature where it centers you on the page appropriately? Buffer for mod chat, says Josh. Hang on. Shared a link with Which one? Josh, we started that one. And we bailed. We got the jury instructions. I bailed because it had signs that it was going where we didn't want to go. It was a domestic battery by strangulation, aggravated battery, aggravated assault, deadly weapon, and false imprisonment. So I don't feel bad about bailing on that one. It didn't sound like a fun one to listen to, the evidence as far as the opening was going. But Josh, thanks for missing that part this morning. No, I'm glad you're here. Sorry. You're just giving you a hard time, Josh. Extra cookies in the mail, right? We do have a good criminal hearing in Dixon right now. This one.
Did you say how far they had backed into the driveway?
But we're waiting for our fireman in the bus to make an appearance, which should happen any moment now. Wait, you mail cookies? Josh will tell you no, that I don't. I've promised cookies, or I apparently promised cookies at one point. I didn't deliver. We need some see Maxwell distance case. Isn't there a song about that? About Max? He's going the distance. He's going for speed. That one? Also want to know what's going on in the co-defendant. I think they're going to put that one on hold until they can name somebody else as a representative. Mr. Angot is deep in thought, probably reading case notes. Distance by Cake, right. I forgot about Cake. What a great band. All right, great question, Abby. Abby says, was there a resolution to the active shooter in Utah stream last night? Had to get off early. The resolution was the tip they got from a church leader about a mental patient and a threat of firearms in the area where gunshots had just been heard, led to somebody who was very close by, but was not their guy. They took him and his mom into custody very briefly for questioning, and were able to very quickly clear him. And basically they dialed back the search until it was gone. Now, last night, about, 7 miles north of there was another incident in Ogden involving the same Ogden Bearcat crew that was there on the first search, where there was another shooting and an explosive that was set off, and a man was taken into custody late at night. I'm not sure if those are connected. The news is asking, but they're not giving any information. So it's possible those two could be connected. They're very close. I mean, there's a valley and a river between the 2 points where the two things happened. And 5-minute drive. So very, very possibly could be connected. All right. All right, we're gonna have to double box this. That's what we're gonna need to do. Let's see. Let's do super source presets, 2 boxes. Do one on the left, one on the right. Box 1 will be channel 2. Box 2 will be channel 8. Nope, we're gonna swap those.
Point where your friend already has a bat.
Yes, sir.
Out. And what's he doing with the bat?
Trying to get him to clean my window off, because what kind of sane human being spits a bloody loogie on someone's window?
You thought that was appropriate?
I don't know what's appropriate, but that's not my say-so.
Would you consider a bat a deadly weapon?
Yes.
Okay. And what was, how do you get someone to clean spit off your window?
Use a bat.
I asked him to clean it off, and then he pulled his little shiv out, and that's when I started to use the bat as telling him, hey,
Mr.
you're not
Angot?
going to get out of that car. And
I'm struggling here to get an answer. I've looked up the Monroe ROA. It looks like there's only one guardian. She did have a GAL.
Clean
but
spit.
you-
off the
Sorry.
window,
Yes,
correct?
after he
Quite the
assaulted
wrong
my
one.
vehicle and vandalized it. Yes,
We
I
need
did.
to back up
He
somehow.
assaulted your vehicle.
And vandalized it. Yes, he did. He spit on my vehicle, and that is disgusting. And I don't know what diseases he may carry.
Were you
And-
gonna use the bat?
No.
Okay. But you did use the bat.
After he tried to get out of the car.
And vandalized his vehicle.
After he spit on my car, yes.
No, it was after you took.
After he, yes,
took
I
the
said
bat
yes.
into
After
your
he
hand.
tried to get out of my
Wait,
car.
hold on just a second. Wait till he finishes asking his question before you begin answering it, and you will let him finish his answer before you ask the next
Yes,
question.
sir.
And this is somebody you don't know at all, never met him before in your life.
Not to my knowledge
All
for
right.
the 5th time.
Do you have a bunch of run-ins with complete strangers like that?
No, sir.
No? You don't have any kind of record of assault or anything?
Well,
like
I
that?
live
sir.
here now. I'm sorry.
And so I guess back to the question, you were gonna threaten or intimidate him
Yes.
with this bat so that he would get out and clean spit off your window?
Yes.
Okay. And in doing so,
He's admitting to a crime
you
here.
struck his vehicle
Yes.
and knocked the mirror off the driver's side door.
Yes.
The same door that he's sitting beside
Yes.
in the driver's seat. Is that correct?
Yes.
Okay. And
Please
you
tell me there's
said
video.
that you hit the mirror so because he actually pulled a knife out of his pocket.
No, I did not.
No, okay. What did you say?
I said that he pulled something that appeared to be a screwdriver out of his pocket.
Screwdriver.
That's what it appeared to be.
Now that's pretty important. Did you tell the
That is
police
what is wrote down in the report.
Did you tell the police a screwdriver?
Yes, that is what is wrote down in the report.
Okay. Have you written your own report?
When I wrote my statement, I said what looked like a screwdriver, and he was using it as a knife, trying to use it as a knife, holding it in his hand like this.
And sitting in his.
Yes, he made sure to wait until I got out to the parking lot before he left because he wanted to see me looking at the spit on my window.
So wrapping that up, he still never got out of the truck, did he?
No, sir.
This entire incident, and you get in your vehicle and leave.
Yes, sir.
And Cameron gets in on the passenger side.
No, he was in his own vehicle.
Oh, he was driving.
How is this guy not the
Your
defendant?
vehicle.
No, he was driving his own vehicle, as I just said.
Okay, so he didn't ride to the store with you.
No, sir. He followed me.
Okay. And you've been drinking?
No, sir. I just got off a 12-hour shift.
You say you started drinking once you got home.
Yes, sir.
Okay. And the night of the bowling alley, were you drinking that night?
Maybe 2 beers by 4 hours.
And you were with your son?
No.
No? You said the female that you were with.
Yes.
Okay, was that a girlfriend?
No, sir.
Okay. Just a friend.
Yes, sir.
And who else were you with?
2 of my other friends that I go bowling with every Thursday.
Okay, what are their names?
Logan Work and Wade Lepowski.
And what is your
Shout out to Logan and Wade.
friend that's a girl? What was her name?
Jennifer Fisher.
And you said that Mr. Ragsdale was with a girl.
He was with a few people. I don't recall who any of them were.
And you know how many people he was with?
Maybe 4, 3, I don't know.
Okay. And one of those was a girl, correct?
Yes, sir.
Or at least one was a girl.
Yes, sir.
And that girl came over and was talking to you, wanted to talk to you.
Yes, sir. She started initiating a contact with the other female and then started talking to me, asking me what my name was.
Okay. And she didn't, well, I'll withdraw that question. You didn't know if Mr. Ragsdale had sent her over there to talk to you?
No, sir. At that point, I didn't even know Mr. Ragsdale was in the bowling alley until I had went up to go bowl and he was leaving.
Okay. And you said y'all were almost getting ready to leave. You're
Yes, sir.
finishing up.
Yes, sir.
And I wanted to make sure I heard you correctly. Where did the only time that you said you saw a gun at the bowling alley
Yes, sir.
in Mr. Ragsdale's possession was when he was leaving and he lifted up his shirt?
Yes, sir. And then he started thrusting in the air repeatedly for about 20 seconds.
Sometimes you talk a little fast for me. He was leaving and what?
He started thrusting the air for about 20 seconds with his shirt pulled up, and he just stood in the same spot in the wheelchair ramp.
Hip. What kind
Doing
of?
with the air? I'm sorry.
He was dry humping the air. Like he was pretty much telling me, he wanted, he was saying F me.
Like this?
No, like he was getting down on it.
Oh, okay.
Yeah.
Okay.
Look at the judge. Look at
Must
the
be
judge.
a new term.
Yeah.
I'm sorry.
So would you call that like some kind of sexual innuendo?
I don't know what it is. It was very disturbing and it made me scared because I was about to leave the bowling alley and I didn't want him to sit out there and wait on me to leave and try to do something outside in the parking lot. So I immediately called the police.
And you're saying with him doing that and making some kind of thrusting movements with his hip, you were able to see a gun?
Yes, sir. He made it very clear to show the gun.
And were you able to describe the gun?
It looked like a black handgun from what I could see. It was just the back of it hanging out, a little bit of it.
Boom, 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 boom.
Did you have a gun?
No, sir.
At your house?
I did not.
Okay.
I've never seen Judge Wolf flustered like we just saw.
And when he was making these thrusting, that's the only time he indicated, or that's the only time you could see him with the gun.
Yes, sir.
Please have him
He
demonstrate.
didn't pull it out. He didn't touch it.
He had his hand on it when he was thrusting. He pulled his shirt up and held it up with his arms like this, and then had his hands on his hips.
Okay.
Like,
That because
can you show us?
Pants are baggy? Or?
Probably because he doesn't know how to wear a belt.
Okay.
I'm sorry, we have Maxwell. We're ditching
Just
you,
a
man.
couple more questions. You said you had a restraining order against him?
Yes, sir.
Okay. When did you take out a restraining order?
It was maybe a week after the shooting had occurred. Actually, I'm pretty sure the detective helped me make sure the restraining order was filed, and we had somebody that was supposed to be watching over my house for a day or two to make sure he didn't come back.
Right. This is the very first time you've ever testified in any of this,
Yes, sir.
right?
Yes, sir.
You didn't testify to any kind of restraining order hearing or anything like that?
No, sir.
No further questions?
And you went back and looked at the video at the market. Did you go back and look at the video
Yes,
at
there's
the
a video.
At the
Bowling alley.
bowling alley?
No, sir, I did not.
There's two videos.
That's because you said you already knew who the perpetrator was.
Yes, sir. And I called the police, and I figured they would handle everything from there.
Okay. And the girl that was with you,
Defendants in
not
red.
not a girlfriend,
No,
but
sir.
the girl that was with you that bowled with you that night, correct?
Yes, sir.
And had she been drinking?
She had one beer. She was driving that night, so she wasn't really drinking.
Okay, but you were drinking.
Yes, sir.
So I mean, were you intoxicated?
No, sir.
No. All right. She was so intimidated that she followed Mr. Ragsdale out of the bowling alley, didn't she?
No, she was telling him to leave because he was taunting me, and she knew that she didn't want me having any interaction with him at all because of the already pending case.
Oh, or are people able to tell you, hey, calm down?
Yeah, I was more or less scared than I was upset. I wasn't very angry or anything. I was actually scared for my life because I didn't want to leave, and then him try to do something to me in the parking lot. That was the only fear I had.
It seems like you, instead of backing down or letting it slide or reporting it to the police, it seems like you react physically. Is that fair to say?
I did not at the bowling alley.
You did not do that at the bowling alley?
No, sir.
Okay. You got kind of upset the last time we were in court and came out and said some pretty
When
aggressive
Cody looked
stuff.
at me dead in my eyes, yes, I did get a little upset, and I think it is a little disrespectful to have the victim walking out to the parking lot with a man who just shot up his house. Would you guys do that with a rape victim?
We were already outside, correct?
Yes.
And you saw us outside.
And then Cody turned around and made eye contact with me.
And we were well down the sidewalk when you made
No,
sure
you
that
guys
you
were,
walked
like,
within
right in
feet of
front of
us.
the
One
door.
at a time, please. Wait for him to finish his question before you begin answering.
We were 40, 50 feet from the front door, and you walked within feet of us and said something to him first. Did you not?
You guys were in the sidewalk on the way to my vehicle. Standing in the sidewalk on the way to my vehicle.
All right. You knew that we were trying to avoid you, right?
No, it made it seem like you were just standing on the sidewalk in the middle of, in the front of the building.
No, we tried to avoid you up here inside the courthouse and inside the courtroom.
I did not see Cody that day because when I came in here, I was told I had to leave the courtroom because there was no room.
No further questions.
Mr. Brooks, you have a redirect. Thank you, sir. Mr. Weaver, you may step down, have a seat in the courtroom.
Have a seat in
Let me call your next witness.
Make eye contact with the defendant. He does not have a seat in the courtroom. He leaves. Wow. There's got to be some videos shown here. Whatever this case is, I'm sure the whole town knows about it. Cody. Different Cody. Can we back up? Let me see. I'm not sure if this judge lets us back up. Hold, please.
Step up, please. Come around, raise your right hand, be placed under.
Let's back up. How far back is it? Let's go back to the beginning. I didn't realize we could back up here. For some reason, I thought we couldn't. All right. We've gone back in time, pretended you didn't see anything that just happened. It's all going to be brand new.
We're going to up some matters a little bit out of order, so we'll take the first case is State versus Cody Hunter Ragsdale.
Cody Hunter Ragsdale. Begin your internet searches now.
We are ready on that motion to revoke bond. Bring your client around.
Hunter Ragsdale. Oh, it's a motion to revoke bond. So there was a previous. Oh. There he is in red. You sit over there, Cody.
All right, this is the state's motion. Mr. Brooks, are you ready? All right. You wish to put on proof or you want to make an opening statement? All right, call your first witness.
Oh, he was the first witness. Oh, it starts with Spice right at the beginning. The judge has no idea.
You will raise your right hand and be placed under oath.
Look at this beautiful courtroom.
We'll pull that microphone toward you. There you go. Thank you.
Oh, he knows how to use it.
Can you please state your name for the record?
Douglas Carl Jr. Weaver.
And Mr. Weaver, do you know a Cody Ragsdale?
Yes, sir, I do.
How do you know Mr. Ragsdale?
From an incident that occurred at the gas station and pursued to my house that evening. I don't recall the exact date.
All right.
That's when you first met him at the gas station?
Would that have been on October 20th, 2024?
Yes, sir.
Okay. What exactly happened at the gas station?
I went into the gas station around 6 o'clock. Not 6 o'clock. I got off work around 4 o'clock, and I got to the gas station somewhere around there. I don't remember the exact time. I got a 12-pack of beer. I went out to the car, and my buddy's sitting out there screaming and yelling at some dude with a bat in his hand because the guy just spit on my window and got back in his car.
The question is, your objection is on what basis? Hearsay?
There's a DNA swab.
When there's an objection, sir, just be quiet until I can make a ruling on it.
There's a DNA swab.
I have no objection. I mean,
All right, we'll sustain the objection.
Can you testify to what you saw?
When I came out to the parking lot, I saw my friend yelling at him, and he was in the driver's seat of the car laughing and pointing at the car and saying he wasn't going to clean it up. He wasn't going to clean it up.
Okay. And did you ever see what what Cody was referring to?
It was a gigantic loogie that had blood in it on my window of my car.
All right, and that's something you actually laid eyes on?
Yes, sir.
Okay, and he was saying, I'm not going to clean it up.
Yes,
I'm
sir.
not going to clean it up. Okay. Do you see that person here in the courtroom today?
Yes, sir.
Where is he sitting and what is he wearing?
Right there, wearing a red Hollister sweater.
Polyester
And
sweater.
after that,
Or
what did you
Hollister,
do?
sorry.
I proceeded to grab the bat from my friend and tell him to please clean it off the window. And I had no problem. I didn't know who he was. And I just had no clue why he spit on my window. And he refused and then told me that he knows who I am and that I robbed him and pretty much that he wasn't going to clean nothing up. And then he grabbed some thing out of the door of his car and went to go get out of the car with it and was pretty much telling me he wasn't going to do nothing, and that started calling me B word and cussing at me, telling me that I robbed him a couple years ago and that he's not cleaning nothing up and that he knows me, he knows where I live and all that kind of stuff.
Okay. Did he make any other type of threats at the gas station?
No, sir. He just told me he knows where I live and that he's got something for me, is what he said.
Okay. And what did you do after this? How did this end at the gas station?
He went to step out of the vehicle with what I assumed to be a screwdriver or something like that. And I swung my bat at his vehicle, and then I got in my car and went to go leave. And he followed me almost all the way to my house and then turned around. And I don't know where he went from there. But I got home. I told my dad what happened. I was sitting there. I opened up a beer, started drinking it. My buddy that went to work with me had left. And 20 minutes go by, a car pulls into my driveway, and my brother and his girlfriend are outside painting pumpkins. And they tell me there's a car coming down the driveway and there's people getting out of it. And then 5 seconds later, you just start hearing gunshots going off.
Okay. And where were you when the gunshots started?
I was
off?
sitting on my couch at first, and then as soon as they told me somebody was in the driveway, I ran out to the porch to see what was happening because I already figured pretty much what was happening.
Had you made it outside before you heard the first gunshot?
No, sir.
Okay. So while you're still in the house, you hear what you think at the time was a gunshot?
Yes, sir.
You run outside to see what it is.
And what time of day is it when this is occurring?
It was right before it got dark. I don't remember the exact time. It was around 4 something. It might have been a little later than that. I don't recall exactly.
Because this happened in the fall. You said October.
Yes, sir. Right when it was about to get dark. It was like 30 minutes before it got dark or something like that.
Okay, so there's still a light out.
Yes, sir.
And what does the makeup of your yard look like? Is it treeless?
There is some trees, but I can see in the fall, because there's no leaves, all the way down to my drive. I can see all the mailboxes next to me and everything down the hill.
But when you exit your house, what are you able to make out?
I see the truck that I seen at the gas station at the bottom of my hill, and there was 2 guys standing there shooting. And after that, my dad went and started running down there with his firearm, and I just tried to get my son and my wife and everybody to the back of the house to get them away from it because I didn't know what was really going to happen. If they were going to run up my hill or something like that. I was scared.
Right. Were you able to make out any individuals?
I couldn't make out individual faces. I just remember seeing the truck that was at the gas station. It was a very easy to remember. That was the same truck because it was a crappy paint job and had a busted mirror on it.
Right. And
I recognize the crappy paint.
You said you weren't able to make out the people. Did you see where they were at?
They were
like where the shots were coming from?
Yeah, they were about 20 feet behind my gate, like into the driveway where they pulled all the way in, and I could see them standing at the back of the truck.
Overruled.
I think he just said what he's able to see, Judge. That's the
I
question.
think the question is, what was he able to see? And he's explaining what he could see. He said he couldn't see the faces of the people, but he's now describing what he saw. Overruled.
So I seen them standing at the back of the truck, and that's when I told my wife, run to the backyard, because we live in a mobile home, and that's not really going to stop bullets. So I was just wondering, how are we going to get them away from all this? Because I thought they were going to try to force their way up the driveway or something. And that's the only thing I was trying to do at that time, was save my family from getting hurt.
Okay. So, yeah, I mean, were you able to make out with your own eyes how many people, like any other descriptors aside from, you can't make them out particularly, but were you able to make out any descriptors of the people?
I seen a tall gentleman, and he was wearing a black hoodie or something around there. I have no clue who it was, and he was holding a long rifle. It looked like, I couldn't tell anything else with that. And then I seen him, I was assuming, somebody on the other side of the car, I don't know who it was, and they were holding what appeared to be a pistol, because like I said, you could see directly into the bottom of my driveway. There wasn't any trees or anything blocking the view. And after that, my dad was running down the driveway, and they started to get in their car and try to leave.
Were you able to make out male or female?
I couldn't tell if it was a male or female, but I've never met a woman that big.
Okay. All right, so one tall individual with a long gun, one other individual with what appeared to be a handgun from your vantage point. About how many shots at that time? Like, how long did this last?
It seemed like it lasted for a long time, but I know it didn't, and it felt like they were just shooting and shooting. But to me, I thought it was around 30 shells. I don't know what was ended up being collected or anything like that, but that's what it sounded like to me because you could tell they emptied everything they had in their gun before they left.
Okay. All right. And where were you when when the shot stopped?
I was running back to the front of the house trying to see where my dad was because the last time I seen him, he was running down the driveway, and that's when they were already peeling out of the driveway.
So had you had an opportunity at that point to get your family to safety?
Yes, sir.
Okay. And where were they at?
I put them in the backyard. We have a shed back there, and I stuck them behind it.
Okay. And who was all on scene at the shooting?
My wife, my brother, his girlfriend, my son, my mom, and my dad.
And who was all in the house at the time when this started?
My mom, my wife, my baby, and me.
And where were the people outside when you exited the house? Where did you see your family and friends outside?
My brother and my sister-in-law were sitting on a picnic table that's right in front of our front porch, right in front of the driveway, and they took off running to see a gunshot and really in the car pulling up, and it was 5-6 feet away from where they were sitting, where one of the bullets were recovered.
Okay. And then, was there any damage to any property?
There is a gunshot hole in the side of my trailer that penetrated through my dad's bathroom and then went through my dog's cage while he was sleeping in it and hit the gun safe that he has in there.
Okay. I guess was that bullet recovered?
Yes, sir.
Probably about 223. What are you thinking?
Was anybody injured?
No, sir.
Okay.
They missed. That's good.
Did you have another incident occur with Mr. Ragsdale?
Yes, sir.
All right. Would that have been in February of this year?
Yes, sir.
All right. What happened? Where did this incident happen?
It happened at Thunder Alley, the bowling alley.
Okay. And going back, your house, where is that located?
It is approximately 20 minutes from the bowling alley.
Okay. And that's where
Mr.
this.
Brooks, did I understand you to say it was February of this year?
Yes, sir.
Well, since February hasn't arrived in 2026.
I'm sorry.
February
2025. Thank you, Judge. My calendar hasn't switched yet.
We were time jumping or something.
Yes,
so.
sir.
When Cody
No,
should
my
be-
internal
have his
calendar
bond
has not
revoked.
reset yet, apparently.
Gotcha, okay.
So February 2025. Okay. The shooting, what was the address of this shooting?
1454 South Bear Creek Road.
All right. Is that located here in Dixon County?
Yes, sir. It's on the Dixon County Bon-Aqua line.
Okay. Now, where did this next incident happen in February last year?
It happened in the Thunder Alley, the bowling alley in Dixon.
Okay, that's located here in Dixon County?
Yes, sir.
Okay. What happened at Thunder Alley?
I was bowling with my friends all night long, and then some lady came to my table and started asking questions about me and asking if I was DJ and all these weird questions. And I pretty much talked to her for a minute and then told her I didn't want to talk to her anymore. And an hour maybe goes by, and I get up and went to go do my last bowl because we're about to leave. And I saw Mr. Ragsdale walking towards the snack bar because he was heading towards the door. And when he looked at me, he put his finger up and then said something to me. So I said, I have a restraining order against you. You're not supposed to be here. You need to leave. And then he starts cussing me out and just saying all sorts of weird stuff, and tells me again with the lady I'm with that that he knows where we live and that he's not done pretty much with us. And when he was going to the door, he stopped and turned around and pulled his shirt up, showing he had a gun in his hip, and then started air humping, like thrusting in the air.
Right. And when he displayed his firearm, how did that make you feel?
It made me scared that he was going to wait for me to leave the bowling alley and then try to shoot me.
The person that displayed his firearm to you that made the humping motions in the air, do you see that person here in the courtroom today?
Yes, sir.
Where is he sitting? What is he wearing?
He's sitting right there, and he's wearing the red Hollister sweater.
Okay. Was somebody with you that day?
I was with 3 friends.
Okay, the judge's face.
And who was anybody standing near you when he displayed his firearm to you?
Yes, sir.
And I mean, you kind of gave a paraphrase of what he was saying. Do you know any specifics of what he was saying that day?
I think he was drunk, so he wasn't making very much sense to me, and I really didn't understand what he was saying, but that I don't know for sure. And he was pretty much threatening the woman that was with me more than me that time, because she was getting in his face and telling him, you need to leave, you need to leave. And he was making more threats towards her, saying that he's not the one, that he'll get something for her. The same thing he said to me at the gas station.
Okay. So, you said he seemed drunk. What do you mean by that?
He was pretty much stumbling around and slurring his speech when he was talking to me. And then based off of the humping the air in the middle of a wheelchair ramp, I'm assuming that might be a part of that, unless it's just mental error.
Wow. Mental error.
Did that end your interaction with Mr. Ragsdale that day?
Yes, sir.
Okay. And what time of day was that?
It was 8 or 9, somewhere around 8 or 9 at night, because we were about to go to Applebee's.
All right. And that incident several months after the alleged shooting?
Yes, sir.
So this is direct. It's cross where it gets spicy here.
Leon, you have questions?
This is where he starts going off. We sort of picked up.
Said that your name is Douglas Weaver Jr., is
Yes,
that
sir.
correct? But Douglas Weaver Sr. also lives in.
Yes, sir.
And that is your home, correct?
Goes by DJ.
Okay. And so you testified that you did not know Mr. Ragsdale and never seen him before.
Not to my knowledge.
I did not know him to my knowledge.
How was it that you were able to provide the name of Mr. Ragsdale to the detective in this case?
The picture we had at the gas station, we showed it to a lot of people, and we showed it to the friend that was with me at the gas station's wife, and she had rode the bus with Mr. Ragsdale for a couple years.
Okay, so you talked to, who is that person? Who did you talk to and gave you the name of Mr. Ragsdale?
Gannett, so I don't know her last name, but it was the picture that I had from the gas station I showed, and she said that is definitely him.
Okay, when did you get that picture from the gas station?
I do not remember the exact day that we went and got the picture. I think it was the day after the shooting.
Were you with the detectives in that?
No.
Were you with the detectives when they reviewed the footage?
No, sir.
You have talked to the detectives and law enforcement on many occasions in this case?
Yes, sir.
Okay, and approximately how many times do you think you've talked to a law enforcement officer regarding this?
3, 4.
Okay, and do you recall when you actually told them that you knew the identity?
Yes, sir.
Okay, and how was it that you knew that where Mr. Ragsdale lived?
Because he rode the bus with my neighbor.
What's your neighbor's name?
Gannett, I don't know her last name. She's Spanish.
How long have you lived there?
I've lived at my house for 11 years.
The Spanish neighbor.
And
Nice.
how long does Lynette live there?
Probably 10.
And you don't know her name?
I don't know her last name. I'm not Spanish, sir.
Apparently, you have
You
to
know
be
it, you're
Spanish
just not-
to know.
Alzer Perez, you want me to spell it out for you? I don't know how to do that either.
Judge is trying not to smile.
And so you just started conducting this independent investigation based on what was your description of the person?
Yes, sir. Based off the fact that I had a picture of his tattoo on his forearm, and then he has the tattoo on his forearm.
Okay.
Kind of made the dots connect.
Okay. And you're saying that she happened to know Mr. Ragsdale, recognized the tattoo, and told you where he lived?
No, she did not recognize the tattoo. She recognized his face.
Okay. I just wanted to be clear. You said that you did not, at no point did you see Mr. Ragsdale or was able to identify Mr. Ragsdale at your residence the night that it
Not to
got
my
shot?
knowledge.
Okay. Because you were in the house when the shooting started, is that correct?
Yes, sir. I was sitting on the couch right next to the front door.
And when the shooting started, you were, I guess you have a son. Did you tell me you're a son?
Yes, sir.
Okay. And you took the son and everybody that was in the house,
Yes, sir.
and you got them out of the house back behind a shed. And by that point, had the shooting stopped?
It was still going while they were running, but when I got back around to the front of the house, it had stopped.
All right. So you were running to the front of the house, and that is when you saw, that's when you said you were able to identify Mr. Ragsdale truck,
Yes, sir.
or the truck that you had seen earlier at the gas station.
Yes, sir.
You were able to see that truck leaving the premises.
Yes, sir.
Okay. And did you say how far they had backed into the driveway?
It was after my gate, which is about maybe 25, 30 feet, they backed in another 20 feet. So it's approximately 50, 60 feet into my driveway.
Okay. So it's about a third of the way up the driveway?
No.
No?
No, my
Oh.
driveway is very long.
Oh, is it?
It wraps around a big hill right there, but you can see all the way down the side of it. It's just a little plot of land right there.
I guess as the bird flies, how far from where the truck, the maximum it entered into your property, how far was that from, say, the front of your trailer?
No, 75 feet, maybe 70 feet.
Okay. And I haven't been out there, but I'm visualizing, are there a lot of, is it open front yard, or are there trees in the front yard?
There is trees.
Trees
Lots
and
of
old
trees?
cars.
Nah.
No? Is it enough trees that where you don't have to cut the yard?
Judge has TikToks.
We don't usually cut the trees or the yard.
Okay, because the grass just doesn't grow under the amount of shade that it gets.
No, because
No.
it's in the woods.
It's in the woods. Okay, so you would then agree there's a lot of trees there, right?
I guess.
Okay. How many would you estimate? How many trees you have in your front yard?
10.
10. Okay.
10 trees.
Now let me take you back to the gas station. At no point did Mr. Ragsdale get out of his truck?
No, sir.
Once you were outside, you don't know if he got out before?
No, I know he got out before.
Well, you were in the store, right?
Yes, sir.
You didn't see him get to the store?
No, I seen the passenger of the vehicle come out of the store.
Okay, all right. But Mr. Ragsdale, you never saw him outside the truck?
No, sir.
And you asked him to go clean up spit on the driver's side
Yes, sir.
window of your vehicle?
Yes, sir.
Okay. And he said that he wasn't going to do it?
Yes, sir.
Okay. You actually went and got some paper towels from somewhere?
Yes, sir.
All right. So is it fair to say that kind of ticked you off a little bit?
Yes, sir. And if he would have just been a man and wiped the damn window off, then it would have stopped a lot of aggression. But the threatening was what really started the aggression.
It would have stopped a lot of aggression on your part, right?
No, his part.
Okay. Well, you said that you had grabbed the bat before you asked him to wipe the spit off.
No, I did not grab the bat before. I did not say that.
Well, then when he refused, then you
Yes, sir.
got
I
more
took the bat from my
aggressive
friend.
and took the bat from Cameron.
Yes.
Now, Cameron was in the store with you as well.
No, he was not.
No, he didn't go into the store at all
No,
with
he
you.
was in the parking lot.
Okay. The entire time?
He might have went in. Like I said, I do not recall exactly.
Okay. So you don't know if Cameron saw him spit on your car or not?
Yes, I do know.
Because of what Cameron told you?
Yes.
But personally, you don't have any personal knowledge that Cameron knows that he spit on your car?
No, but I trust my friend.
And you trust your friend to the point where your friend already has a bat
Yes, sir.
out. And what's he doing with the bat?
Trying to get him to clean my window off because what kind of sane human being spits a bloody loogie on someone's window?
And you thought that was appropriate?
I don't know what's appropriate because that's not my say-so.
Would you consider a bat a deadly weapon?
Yes.
Okay. And how do you get someone to clean spit off your window?
I asked him to clean it off, and then he pulled his little shiv out, and that's when I started to use the bat as telling him, hey, you're not going to get out of that car and try to stab me, sir.
Well, no, the question was, you were trying to force him. Cameron was trying to force him, and then you were trying to force him to clean spit off your window, correct?
Yes, after he assaulted my vehicle and vandalized it. Yes, I did.
He assaulted your vehicle?
And vandalized it. Yes, he did. He spit on my vehicle, and that is disgusting, and I don't know what diseases he may carry,
Were you
And-
gonna use the bat?
No.
Okay.
Shade.
But you did use the bat.
After he tried to get out of the car.
And vandalized his vehicle.
After he spit on my car, yes.
No, it was after you took.
After he, yes, I
took the
said
bat
yes.
into
After
your
he
hand.
tried to get out of my
Wait,
car.
hold on just a second. Wait till he finishes asking his question before you begin answering it. And
This
you will
gets
let
better
him
with the
finish
backstory.
his answer before you ask the next
Yes,
question.
sir.
And this is somebody you don't know at all, never met him before in your life.
Not to my knowledge
All
for
right.
the fifth time.
You have a bunch of run-ins with complete strangers like that?
No, sir.
No? You don't have any kind of record of assault or anything like that?
No, sir.
All right. And so I guess back to the question, you were gonna threaten or intimidate him
Yes.
with this bat so that he would get out and clean spit off your window?
Yes.
Okay. And in doing so, you struck his vehicle
Yes.
and knocked the mirror off the driver's side door.
Yes.
The same door that he's sitting beside
Yes.
in the driver's seat. Is that correct?
Yes.
Okay. And you said that you hit the mirror because he actually pulled a knife out of his pocket.
No, I did not.
No. Okay. What did you say?
I said that he pulled something that appeared to be a screwdriver out of his pocket.
Screwdriver.
That's what it appeared to be.
Now that's pretty important. Did you tell the
That is
police-
what is wrote down in the report.
Did you tell the police a screwdriver?
Yes, that is what is wrote down in the report.
Okay. Have you written your own report?
When I wrote my statement, I said what looked like a screwdriver, and he was using it as a knife, trying to use it as a knife, holding it in his hand like this.
And sitting in his.
Yes, he made sure to wait until I got out to the parking lot before he left because he wanted to see me looking at the spit on my window.
So wrapping that up, he still never got out of the truck, did he?
No, sir.
This entire incident, and you get in your vehicle and leave.
Yes, sir.
And Cameron gets in on the passenger side.
No, he was in his own vehicle.
Oh, he was driving.
Yes, sir.
Your vehicle.
No, he was driving his own vehicle, as I just said.
Okay, so he didn't ride to the store with you.
No, sir. He followed me.
Okay. And you've been drinking?
No, sir. I just got off a 12-hour shift.
You say you started drinking once you got home.
Yes, sir.
Okay. And the night of the bowling alley, were you drinking that night?
Maybe 2 beers by 4 hours.
And you were with your son?
No.
No? You said the female that you were with.
Yes.
Okay, was that a girlfriend?
No, sir.
Okay. Just a friend.
Yes, sir.
And who else were you with?
2 of my other friends that I go bowling with every Thursday.
Okay, what are their names?
Logan Work and Wade Lepowski.
And what is your friend that's a girl, what was her name?
Jennifer Fisher.
And you said that Mr. Ragsdale was with a girl.
He was with a few people. I don't recall who any of them were.
And you know how many people he was with?
Maybe 4, 3, I don't know.
Okay. And one of those was a girl, correct?
Yes, sir.
Or at least one was a girl.
Yes, sir.
And that girl came over and was wanted to talk to you.
Yes, sir. She started initiating a contact with the other female and then started talking to me, asking me what my name was.
Okay. And she didn't, well, I'll withdraw that question. You didn't know if Mr. Ragsdale had sent her over there to talk to you?
No, sir. At that point, I didn't even know Mr. Ragsdale was in the bowling alley until I had went up to go bowl and he was leaving.
Okay. And you said y'all were almost getting ready to leave. You're
Yes, sir.
finishing up.
Yes, sir.
And I wanted to make sure I heard you correctly. Where did the only time that you said you saw a gun at the bowling alley
Yes, sir.
in Mr. Ragsdale's possession was when he was leaving and he lifted up his shirt?
Yes, sir. And then he started thrusting the air repeatedly for about 20 seconds.
Sometimes you talk a little fast for me. He was leaving and what?
And he started thrusting the air for about 20 seconds with his shirt pulled up, and he just stood in the same spot in the wheelchair ramp.
He was doing what with the air? I'm sorry.
He was dry humping the air. Like he was pretty much telling me he was saying F me.
Like this?
No, like he was getting down on it.
Oh, okay.
Yeah.
Okay.
Look at the judge.
Must be a new term.
Yeah.
This the best part.
So would you call that like some kind of sexual innuendo?
I don't know what it is. It was very disturbing, and it made me scared because I was about to leave the bowling alley, and I didn't want him to sit out there and wait on me to leave and try to do something outside in the parking lot. So I immediately called the police.
And you're saying with him doing that and making some kind of thrusting movements with his hip, you were able to see a gun?
Yes, sir. He made it very clear to show the gun.
And were you able to describe the gun?
It looked like a black handgun from what I could see. It was just the back of it hanging out, a little bit of it.
Did you have a gun?
No, sir.
At your house?
I did not.
Okay. And when he was making these thrusting, that's the only time he indicated, or that's the only time you could see him with the gun?
Yes, sir.
He didn't pull it out, he didn't touch it?
He had his hand on it when he was thrusting. He pulled his shirt up and held it up with his arms like this, and then had his hands on his hips.
Okay. Is that because his pants are baggy? Or?
Probably because he doesn't know how to wear a belt.
Okay.
People in the audience are laughing.
Just a couple more questions. You said you had a restraining order against him?
Yes, sir.
Okay. When did you take out a restraining order?
It was maybe a week after the shooting had occurred. Actually, I'm pretty sure the detective helped me make sure the restraining order was filed, and we had somebody that was supposed to be watching over my house for a day or two to make sure he didn't come back.
Right. This is the very first time you've ever testified in any of this?
Yes, sir.
Right?
Yes, sir.
You didn't testify at any kind of restraining order hearing or anything like that?
No, sir.
And you went back and looked at the video at the market. Did you go back and look at the video at the bowling alley?
No, sir, I did not.
Okay. That's because you said you already knew who the perpetrator was?
Yes, sir. And I called the police, and I figured they would handle everything from there.
Okay. And the girl that was with you,
Yes,
not
sir.
your girl, not a girlfriend,
No,
but
sir.
the girl that was with you that bowled with you that night, correct?
Yes, sir.
And had she been drinking?
She had one beer. She was driving that night, so she wasn't really drinking.
Okay, but you were drinking.
Yes, sir.
So I mean, were you intoxicated?
No, sir.
No. All right. She was so intimidated that she followed Mr. Ragsdale out of the bowling alley, didn't she?
No, she was telling him to leave because he was taunting me, and she knew that she didn't want me having any interaction with him at all because of the already pending case.
Oh, or are people able to tell you, hey, calm down?
Yeah, I was more or less scared than I was upset. I wasn't very angry or anything. I was actually scared for my life because I didn't want to leave, and then him try to do something to me in the parking lot. That was the only fear I had.
It seems like you, instead of backing down or letting it slide or reporting it to the police, it seems like you react physically. Is that fair to say?
I did not at the bowling alley.
You did not do that at the bowling alley?
No, sir.
Okay. You
I
got
think we're going to fast forward
kind of
just a little
upset
bit.
the last time we were in court.
We've seen all this part.
And came out and
when Cody looked at me dead in my eyes, yes, I did get a little upset. And I think it is a little disrespectful to have the victim walking out to the parking lot with a man who just shot up his house. Would you guys do that with a rape victim?
We were already outside, correct?
Yes.
And you saw us outside.
And then Cody turned around and made eye contact with me.
And we were well down the sidewalk when you made
No,
sure
you
that
guys
you
were,
walked
like,
within
right in
feet
front
of
of the
us.
door.
One at a time, please. Wait for him to finish his question before you begin answering.
We were 40, 50 feet from the front door, and you walked within feet of us and said something to him first. Did
You
not?
guys were in the sidewalk on the way to my vehicle. Standing in the sidewalk on the way to my vehicle.
All right. You knew that we were trying to avoid you, right?
No, it made it seem like you were just standing on the sidewalk in the middle, in the front of the building.
No, we tried to avoid you up here inside the courthouse and inside the courtroom.
I did not see Cody that day because when I came in here, I was told I had to leave the courtroom because there was no room.
No further questions.
Mr. Brooks, you have a redirect. Thank you, sir. Mr. Weaver, you may sit down, have a seat in the courtroom.
The officer's next up.
Let me call your next witness.
He chooses not to stay in the courtroom. I want to see what happens to our defendant here. Is he going to get? I think he's going to get revoked. What do you think? That was a previous hearing that happened at the parking lot. These guys have had a couple of run-ins. You can see the gentleman on the back row looks like he's about to get up. It's like, that's where I was going, man.
Step up, please. Come around, raise your right hand, be placed under oath. Have a seat.
Court clerk is not mic'd, so we don't get to hear the whole oath. But he agreed, whatever it
Can you
was.
please state your name for the record?
Officer Joel Moss, City of Aaron Police Department.
Okay. Where were you employed on or about February 13th of 2025?
As a police officer with the City of Dixon Police Department.
Okay. Did you have an occasion on that date to respond to Thunder Alley?
Yes, sir.
Is that located here in Dixon County?
Thunder
Yes, sir.
Alley.
What brought you to Thunder Alley?
We were dispatched to a possible aggravated assault.
Okay. And what was your participation in that investigation?
As the initial officer and the investigating officer for that assault.
Okay. And where did you initially go as part of your investigation?
I responded to Thunder Alley. I made contact with the victims. I'd have to glance up my affidavit to get their exact names. But I made contact with the victims and also witnesses, got their statements, got the suspect information to include his vehicle information, put out the information over the radio for be on the lookout for on his vehicle, so that way the other officers could start looking for his vehicle. Then I left Thunder Alley and we started searching for the suspect's vehicle.
And were you able to eventually make contact with the suspect?
Yes, we were. And officers initiated a felony traffic stop at close to Highway 46 and the interstate. And we placed Mr. Ragsdale in custody.
You say Mr. Ragsdale. Do you see, are you referring to Cody Ragsdale?
Yes, sir.
Do you see that person here in the courtroom?
Yes, sir.
Can you describe where he's sitting and what he's wearing?
He's wearing a red shirt, sitting next to the defense attorney.
And when you first make contact with Mr. Ragsdale, does he make any statements?
He had made a spontaneous utterance to Officer Hagewood, advising that this was in relation to Thunder Alley. We had also located a semi-automatic handgun on his person.
So before questions ever asked, he said, "Is this about Thunder Alley?"
Yes, sir.
Okay. You said a handgun was found. Where was that located?
In his jacket pocket.
Okay. And can you describe that handgun?
He's not.
It was a semi-automatic pistol. I would have to glance at my affidavit to get the exact model number due to the length of time since then, but I remember it was a semi-automatic pistol.
I think it was a Taurus.
Okay. And
guess the brand.
did he give you any issues as he's been taken into custody?
Yes, sir. He refused to get in the back of the patrol car when I tried to place him in it, and we eventually had to utilize my OC spray him with it, then get him in the back of the car, and he continued to cuss us out. Had to push him into the back of the car forcibly to get him into the back of my patrol car because he did not want to get into it.
So how did he resist?
He's getting revoked.
He kicked at the door and was pushing on the seat, refusing to get into the car.
Okay. Did he make any other statements in regards to the incident at Thunder Alley?
I do not recall.
Okay. Did you make any other observations about Mr. Ragsdale at at the traffic stop?
As I recall, he was under the influence of, I'd have to double check my affidavit, but
If you, would you like to refresh your memory?
Yes, sir.
Judge, may I pass up his warrant?
You may.
Please tell us what kind of gun it was. I'm guessing Taurus.
Take your time, officer.
Don't think it was a Beretta. Don't think it's a Glock. Could be a Ruger, maybe. Like a P89 or a P95. Doesn't look like a Sig Sauer sort of guy.
Were you able to refresh your recollection?
yes, sir.
When you say you think he was intoxicated, like, I guess what led you to believe that was potential?
He smelled of the odor of marijuana.
Okay. And I'll ask the question, like, did y'all do any field sobriety task or anything of that nature?
No, sir.
Okay. Is there any reason why y'all didn't y'all didn't pursue a DUI investigation?
No, I didn't see him driving, so.
Okay, so
Yeah.
that would have been another officer to pursue that if that was the case?
Yes, sir.
Okay. That's all I have this witness, Judge.
McGowan, you have questions?
So I take that, you weren't the officer that stopped the vehicle, correct?
No, sir. I responded as the backup officer.
Okay, but, and I guess that response to the stop of that vehicle, you know about how much longer that was after I guess your arrival at Thunder Alley?
I do not recall.
Okay, but were you the first officer on Thunder Alley?
Yes, sir.
Okay, so your involvement in this case deals directly with Thunder Alley and then the stop where some marijuana was found?
Yes, sir. And the firearm.
Okay. And did you interview Mr. Weaver Jr. at Thunder Alley?
Who are you looking at?
The younger gentleman that is one of the victims at the earlier shooting at his trailer.
I do not recall if he was one of the victims or not at Thunder Alley.
Please.
Why is the officer looking to the prosecutor before he answers? Sorry, I was reading a news article somebody posted in the Facebook group. Man arrested after 100 human remains found in basement linked to dozens
You don't
of
know
grave
if you
robberies.
interviewed Mr. Weaver?
He was the younger gentleman that I saw come in who was interviewed or on the stand before me. Is that correct?
You saw him on the stand?
Let me go off on a different direction. Maybe we'll get there. You did interview people?
Yes.
At Thunder Alley, okay. And from those people, you were able to get a description of the car?
Yes.
Correct?
Yes.
And you put that description of the car out?
Yes.
And at some point in time, you were told that, based on that description, did you, and based on your be on the lookout, did you say that this individual could have a weapon?
Yes, I did, because based on the interviews from the people at Thunder Alley, he had lifted up his shirt after an argument and showed the firearm, which was under his shirt.
While doing
and
what?
The argument was based on allegedly Mr. Ragsdale had shot up a house of some of the people prior to the incident at Thunder Alley.
All right. And
grave robbing.
Tell us what you remember. Do you recall who it was that told you about him lifting up his shirt?
I have the name written down in my affidavit, as I recall.
Okay. I didn't read the whole thing. I didn't want to delay the court, but.
It wasn't very interesting. I didn't read the whole thing. I only got through the first paragraph, and I'm like, yeah, I'm done.
I'm going to let you find it.
The bailiff's like, I want to hand it to him. Can't hand it to him directly. Please tell us what kind of gun it was. I need to know.
All right, so Mr. Weaver advised that Mr. Ragsdale approached him and lifted his shirt, displaying a gun he had on his hip, and put his hand on it.
And so now that refreshed your memory, is that right?
Yes, sir.
And do you remember Mr. Weaver Jr. saying that Mr. Ragsdale approached him?
Yes.
Do you remember Mr. Weaver Jr. saying anything about him observing the firearm while he was doing some kind of thrusting motions with his hip?
He said he had lifted up his shirt and placed his hand on the firearm, which was located on his hip.
Do you remember any kind of thrusting motion or any kind of
I do not
vulgarity
recall
or
that
anything like
exact
that?
statement, sir.
Okay. Would that have been important for you to include it in a report?
It might be on my main report, but for the affidavit, which states probable cause, no, that was not important.
You did do a report.
Yes, sir. I did a full report.
Okay.
To include victim statements.
Okay. And you, did you ever talk to Mr. Weaver Jr. after this incident?
No, sir.
Okay. So that's the only night that you've ever interviewed him?
Yes, sir.
And it was strictly about Thunder Alley?
Yes, sir.
And what he alleged to you as an assault by the display of a deadly weapon?
Yes, sir. And then follow-up investigations have been conducted by the detectives division.
What was his intoxication level, do you think?
I do not recall.
Did you smell any alcohol in him?
I know it was in a bowling alley with a bar, so I don't recall whether he was intoxicated or not.
And were you aware that, and during their statement, or anybody that you interviewed that night, were you ever told that someone followed him out of the bowling alley?
I do not recall, no.
And last question, did you secure the video at the bowling alley?
We were unable to retrieve it.
No.
I contacted Thunder Alley a few times. I was not able to get the video from them.
You just
they had cameras, correct?
Yes, sir.
All right, and they had those cameras functioning that night?
The people working that night weren't able to get the video that night.
Okay, but you asked them for it that night?
Yes, sir.
Okay, and then you followed up about how much longer after that you followed up?
And the following few nights, Officer Purtle, who was also a security officer there, tried contacting the owner, trying to get a hold of them to get the video as well.
And you took the lead in this Thunder Alley investigation, right?
Yes.
Okay. And they told you, what was the reason that they didn't have the video anymore?
I do not recall.
Okay, but you would have put that in your report, that you attempted to get the video and they were unable to provide it for whatever reason?
Yes, sir.
Okay, thank you.
Brooks, any further follow? Thank you, Officer. You may stand down. Mr. Brooks, you may call your next witness.
Calling, just detective.
Step right around here.
We're hung up.
Raise your right hand and be placed under oath.
This is just a revocation hearing. The judge has other things on his docket.
Can you please state your name for the record?
Detective Jim Gardner,
And where are you employed?
Dixon County Sheriff's Office.
And what is your position?
I am a detective.
And were you employed in that capacity on or about October 20th of 2024?
Yes, I was.
Did you have an occasion to respond out to an address on a shooting?
Yes, sir.
Do you remember what the address was?
It was on South Bear Creek. I don't recall. 1159, something like that. I'm sorry.
Pull that
I'm sorry.
microphone base toward you. If you can pull it close to you as possible.
It was on South Bear Creek. I don't remember the mailbox number.
Okay. If you would have wrote in your warrant 1450. correct?
Yes, sir.
Is that located here in Dixon County?
Yes, sir. It's in Dixon County.
And that was in response to a shooting?
Yes, sir.
Okay. When you get to the scene, what is your role?
I was on call that night, and I was dispatched out there because patrol was out there because the Weavers had called in and reported the incident.
Okay.
I was out there to investigate.
And was there evidence, once you get on scene, was there evidence of a shooting?
There was, it was 20 spent shell casings I recovered from the driveway. Yes, sir.
Okay. In the driveway area, you said?
Yes, sir.
Okay. You've heard
what caliber?
Doug Jr. testify this morning. Would his testimony be consistent with where these shell casings were
Yes,
found?
sir. They had a gate that was approximately 25 feet from the main road. Maybe another 20, 30 feet from that is where there was evidence of vehicle tire tracks in the gravel, and on each side of the vehicle is where the shell casings were picked up.
And were they all, were they located in one area?
Yeah, it appears that wherever they were fired from, the rifle and gun were in the same location because they were all discharged in the same spots from where they would have been standing.
Were there any indications in the driveway as far as a vehicle, were there any signs that a vehicle came to rest at that area?
There were, in the gravel, you could see where a vehicle had backed up and pulled forward. It was too big a gravel to get a tire track, a tread mark from it. But you could see the one had backed in there and then taken off, and it had spun just a little bit. So you could tell that it was consistent with what was reported.
Was there any damage on the property consisting with shots fired?
In the residence, we found, on the exterior of the residence, there was a bullet hole in the siding of the trailer going into the residence to where the bullet would have entered the residence. There was a hole in the wall, and then we found a lead bullet laying there on the side where it had hit, excuse me, the side of a gun safe that was there, and it come to rest, its final rest, right there on the carpet and on the side of it.
And was that collected?
Yes, sir.
As far as potential victims, who was on scene when you arrived?
When I arrived on scene, there was Mr. Weaver, junior, senior, the wife, his other son, I can't recall his name. There were 7 people on scene when I was there.
Okay. And then, was anybody injured?
No, sir.
Okay.
Getting back to the bullets, there was another bullet that was located in the side of a tree, but we attempted to dig it out and couldn't recover it. But it was a fresh hole, and the bark was missing. So there was two bullets that we found up in there, and that was right in front of the house.
Okay, so that tree, would it have been between the house where these people were allegedly at and where the evidence of shell casings were at?
Where the vehicle was parked, their driveway went around, and the house was parallel to the road, and that tree was between where the vehicle was parked and where the residence is at.
Okay. How were you able to develop a suspect in this case?
That night, they advised that there was 2 people that was identified as, they didn't know who they were. The following Monday, when I went out there, the store had allowed them to see the video, and they were able to put a name on Mr. Ragsdale.
Okay. Now, were you able to view this video?
I was able to get it that following Monday. Yes, sir.
Okay. Now, you heard Mr. Weaver's testimony concerning the incident at, is it Tuffy's?
Tuffy's Market.
Yeah, okay.
Yes, sir.
That's how I know it. Tuffy's Market near the Bon Aqua-Dixon line?
Yes, sir.
Okay. You were able to view that video?
We didn't see it that night. There was another employee, and he didn't know how to operate the camera, so the following Mondays when we were able to get it when the manager was present.
But you said the victim had seen it in between
sometime over that weekend, yes, sir.
Okay. Were you able to collect it and preserve it?
Yes, sir. I do have a copy of it.
And were you able to eventually view it?
Yes, sir.
What did you see on the video?
On the video, it shows actually Mr. Ragsdale's in the store, Mr. Weaver's in the store. The video they're not in there together making contact with each other. They're just both paying customers that go up to the register. It shows when Mr. Weaver goes outside and the altercation out in the parking lot. Mr. Weaver gets some paper towels and appears, it's consistent with the story that he's trying to get Mr. Ragsdale to clean the spit off the vehicle. And then there's Mr. Weaver swings his bat and hits the side view mirror on the truck, and then they all get in their vehicles and just drive off.
Okay. Were you able to end up, like, the whole spit and blood, like why is that even, like, why is that relevant to this case?
Several weeks prior to that incident taking place, Mr. Ragsdale accidentally shot himself. He shot himself in I believe in the lower chin. I think he lost a couple teeth and the bullet came out. So he still had gauze in his mouth and he was bleeding from that. That would have put the blood in the loogie that ended up on the driver's side door window.
Darwin Awards?
Are you able to make out Mr. Ragsdale in the video?
When he's at the register, yes. And then the same clothing, you can see him out going towards the vehicle that he's sitting in.
And are you able to positively identify him to that video?
At the store, yes.
Do you see that person here in the courtroom?
There's Mr. Ragsdale right there in the red shirt.
Did you eventually make contact with Mr. Ragsdale?
I did not have contact with him until we took him into custody.
Did he still have injuries from that gunshot wound? Or?
Yes, he still had gauze on his face.
Did he say anything?
Just that he didn't have anything to do with it.
Okay. All right. That's all I have, Judge.
Mr. McGowan, you may cross-examine.
Yes, sir, I am.
And his mouth at the time of the gas station incident, it was wired shut. It had.
I don't believe so.
You don't think so?
He's shaking his head no, so I'm going to agree with him no.
All right.
The defendant.
He was talking.
What's that?
He was talking when I talked to him on Monday, or whatever day it was. I spoke with him in person when we served the warrants.
That's how you remember it, right?
That's how.
You remember him talking with no type of impediment at all?
Correct.
Okay. All right. And did he end up this interview? Was that after he got arrested?
Oh, yeah, it was while we were serving the warrant, yes.
Oh, okay, okay.
He was Mirandized, and then I asked him a couple questions, and it was.
But you don't remember him having any problem at the time?
Speaking?
Yeah, speaking.
No, sir.
Okay. And briefly, the video that you watched from the store, he never got out of the vehicle, did he?
Yes,
Well,
he was in
sorry.
there was video of him in the, go ahead.
Let me rephrase that. That was kind of vague. After.
That was incorrect, not vague.
After he exited the vehicle and got back into his truck, and Mr. Weaver approached his truck, he never got out of the vehicle at the gas station again.
After he was in the store and went back to the vehicle, no, sir, he did not get back out of the vehicle.
Other than the alleged spitting, the only person that on the video that seems to be
In the video,
is the victim in this case.
in the video, he is seen walking over to the driver's side window of the van.
Okay.
And then he gets back into his vehicle. It's a distance where you cannot see the spit, but later it was recovered off the window.
So was that spit saved? I mean,
Yes,
there's a
sir.
DNA swab.
Yes, sir.
Have y'all sent that off for testing?
It's been sent off. I'm sure they're done with it by now, maybe. I'll have to check on that.
And you said that there was a slug that was recovered from inside the trailer,
Yes, sir.
and that was saved in evidence.
Yes.
And that's been sent off for ballistic
It's
evidence.
been sent off, but it was too damaged to get anything from it.
And was that the complete slug, or was that shrapnel from from a,
It was the lead portion of the slug, and it was damaged to where they couldn't even tell what the caliber was.
and you said there was another gunshot strike inside the trailer or
Inside of a tree.
inside of a tree?
Yes, sir.
So we have one in a tree, a strike in a tree, and a
Yes.
strike in the trailer.
Yes.
Find any others?
No, sir.
And how many shell casings did you find?
20.
How many?
20.
You found 20 shell casings
Yes,
at
caliber.
the scene.
Yes, sir.
I'm guessing 9mm
And
and
only
223.
two strikes.
Yes, sir.
And that it's your understanding that only one person was out in the front yard that could possibly identify people.
I was told that Mr. Weaver Jr. was on the front porch and Mr. Weaver Sr. was standing in the driveway. And I told you how the drive swoops around. You could see directly down to where the gate is from where his truck was parked. And he said he was at his tailgate of the truck when the incident began.
Well, Mr. Weaver Jr. never identified any specific individual, did he?
He identified the truck.
He identified the
as the
truck.
same truck from the.
Now, has Mr. Weaver Sr. identified any specific individual?
He identified Mr. Ragsdale.
Was that in a photo lineup?
It was on a lineup with me. It was on where the gas station allowed them to go look at the video over the weekend. And that's where I think they took a picture with their cell phone.
So the victim went and conducted an investigation at the gas station, looked at the photo at the gas station, and then
Yeah,
you were informed that he knows
they allowed him to look at
who
the
it
video.
was and where they live.
Yes, somewhat in that order, yes, sir.
And did he tell you who it was that told him the identity of the
It
Mr.
was
Ragsdale?
it was a female that they ran with. I don't remember.
You know her name?
I'm sure it's in my report. Maybe I think it's on Mr. Weaver Sr.'s written statement.
Now, there's been some testimony, and you heard this testimony. I know this has been an issue. You heard testimony from Mr. Weaver Jr. that he doesn't know Cody Ragsdale. This is the first time, October 20th was the first time that he'd ever seen him, in his understanding. You hear him say that? Did you hear Mr. Weaver Jr. say that?
Yes, I heard him say that.
Okay. And has your investigation revealed that that might not necessarily be true?
There was, from what I understand, there was maybe some type of an altercation somewhere in the past years ago. And that was just hearsay what I've heard.
But you didn't get that information from Mr. Weaver Jr. or Mr. Weaver Sr. or anyone from his family?
No, I think I got that from Cody.
From who?
Cody Ragsdale.
All right. And that altercation was what he described to you as an aggravated robbery. Something was taken from him at gunpoint, correct?
Yes. Well, not gunpoint. I think there was a taser involved.
Now, have you asked the Weavers about that?
Yes.
Okay. And they just denied that?
Yes.
Taser?
And have they given you any kind of reasonable answer as to how it was that Mr. Ragsdale would know him and how he would know where he lived?
No, the area, they're both their residents are probably within a mile of each other. They probably frequent at Tuffy's. I don't know.
Or Mr. Ragsdale doesn't live within a mile of the Weavers, does he?
By the way, crow flies probably pretty close to it.
How about now? Does he live there, close there now?
I don't know where Mr. Ragsdale lives now.
Okay.
He's about to live in
You know who he
jail.
lives with?
I have no idea. He was living with his father at the time.
Haven't been keeping an eye on him?
No, sir.
Okay. Ballistics on the, there's been several guns recovered in all
Yes.
this. All right. Has the ballistics from any slug that was found inside the house or possibly in a tree, you just saw the strike in the tree, correct?
Yes.
So you only got one slug from the house?
Correct.
Partial slug?
Correct.
Has that matched in any gun that's been associated with
The one that was recovered could not be identified. They don't actually use ballistics. They use the cartridges, the strike of how the hammer falls on the cartridges. And the bullets that were recovered and the two weapons I got, they're not matches.
Okay. They did not match.
No.
So any gun that has been associated with Mr. Ragsdale,
If you say any gun, the two guns that I was given, there's multiple guns and videos that I've never been allowed to see.
multiple guns and videos. So there's the video from the bowling alley, correct?
Yes.
Well, no, we don't have any video from the
No.
bowling alley.
No.
I'm sorry.
Yeah, you're correct.
That wasn't a trick question.
You're correct, right.
All right. There's the statement that he had a gun at the video. There's a statement that he had a gun at the bowling alley, correct?
Correct.
And then at some point, we don't know how long, later that night, he's pulled over on a traffic stop.
Correct.
And there's a gun recovered.
Correct.
Now, did any of the shell casings in the house match that gun?
Different caliber, from what I understand.
So you didn't, so no need to even test it, correct?
It wasn't my case, so I,
Okay. Well, that would help your case, would it not?
when I found out it was not the same caliber, there was no reason for me to go any farther with it.
And then, said the same guns in the video. There's no video from the trailer. They told you they didn't have any cameras, correct?
Correct.
And so there was, I guess, at some point, he was arrested on the warrant, and there were some guns seized from his house.
Two guns were given me from his house, yes. His father gave me two.
Did he give those to you, or?
His father did, yes.
His father did, okay. Is that when he was being arrested, or?
Same day, yes,
Was that part of an investigation leading?
Same day.
Same day, okay. And those two guns, are you saying don't match?
The strikes from those two guns do not match the strikes on the evidence that was picked up from the driveway.
Okay. No further questions.
Redirect. Thank you. Detective, you may step down. State have any other proof? State has rested their case on the motion. Mr. McGowan, do you have any proof you wish to offer?
It says I was thinking about calling somebody.
I was going to ask him about.
Gonna call the defendant.
You want to put him on for that limited purpose, I'll allow it.
Limited purpose question. Interesting.
All right. Bring your client around. Mr. Ragsdale, come forward, raise your right hand, and let's place you under oath.
And I'll keep it very limited.
Yeah, those pants, that's a style. I can't wait to hear it.
Mr. Ragsdale,
I'm guessing he mumbles.
what is your physical address right now? Where do you live?
1150 Dixon.
Okay. And who lives there with you at that residence?
My dad, and then my baby mama.
My baby mama.
Kid.
Okay. And you said a kid. You're a kid?
Sir.
Does your dad have a significant other that lives there?
No.
Okay. And how old is your child?
She'll be 1 coming in March.
Okay. And do you work?
Yes, sir.
Do you provide support, financial support for help
Yes.
pay the bills, pay the
Yes.
groceries?
Yes.
Okay. And where do you work?
Sam Jordan Construction, LLC.
How often do you work?
Well, now lately, the past couple months, we ain't been working that much. He's still trying to find jobs to do.
All right.
His company's only been open a couple of years.
But it's construction work, is that right?
Yes, sir.
And that's been a little slow during the winter?
Yes, sir.
Slower than what it is in the summer?
Yeah.
So were you busy this summer working?
Oh, yeah.
Is where you live now, is that within a mile of where these other folks live?
I assume so. South Bear Creek's right down the road.
Okay, so that's where you were living at the time this has happened?
Yes, sir.
No further questions.
Mr. Brooks, you have any questions on that issue? Thank you, Mr. Ragsdale. You may step down.
The lawyer was trying to prove.
McGowan, you have any
more
other
than-
witnesses?
More than a mile away. And the witness
Do you have
said
any
no.
rebuttal proof? I'll hear you an argument.
Here we go, closing arguments.
Possession. In September of 2024, he picks up these warrants for a shooting that had occurred, where there's compelling evidence that one did occur, and then he is one of the people that participated in said shooting. That happened in October 2024. And then the subsequent year, 2025, in February, there's another incident at the bowling alley where he is recklessly showing off firearms, placing people in fear. And that's corroborated by the subsequent contact with police where he just utters, is this about the incident at Thunder Alley? So he shows knowledge of what he's being stopped for right then and there. And then a subsequent firearm was located on his person. He has a trouble in abiding by the conditions of his release, and he is a danger to the community.
Mr. McGowan?
Your Honor, I know this is not a trial, and I'm not going to belabor and argue credibility of witnesses and/or lack of any kind of factual evidence. I know my client is wrong because he was apparently had a firearm, which he wasn't charged with, by the way, and he wasn't charged with the DUI. He was charged with simple possession and paraphernalia, and that's the indictment before this court. But I think there's some problems with the evidence in this case. I think there's going to be a lot of investigation that needs to be done. My client is young, but he is a father. He needs to be working. He lives with his dad. It's concerning to me. I didn't realize that they lived that close to one another. But I think the bonds conditions can be amended to at least an extent to require maybe GPS monitoring or maybe even require him to live in a different place with his significant other and his small child. But he needs to be out working, and this bond condition or motion to revoke bond, I don't think was filed until October of 2025. The Thunder Alley happened in February of 2025, and then the original incident was in October 2024. And he's been to court. Can't tell you how many times he's been to court, but this is the first time that he's actually sat down in front of a judge, and we've actually taken proof. I think he understands. I think his record on bond reflects that he can abide by conditions of the bond without it being revoked and him sitting in jail. Thank you.
Well, I would disagree with that last statement, Mr. McGowan, respectfully, because you say that his record on bond indicates the condition. He applied with, the original charge was a possession charge and misdemeanors, and then he's been charged with the shooting incident, which is the much more serious situation because that involves reckless endangerment, aggravated assault, and so forth. And those are felonies. And then more concerning is this one, the docket number 2025 CR 82 from the February incident at Thunder Alley, where he has now been charged with aggravated assault, 2 counts of that, as well as the violation of the order of protection and resisting arrest. So the violation of the order of protection is certainly an indication that he is not likely to continue to abide by the terms of any kind of bond condition.
The bailiff has moved into position.
Tennessee Code annotated 4011, 141, subsection D provides that if after the defendant is released upon a personal recognizance, an unsecured personal appearance bond or any other bond approved by the court, the defendant violates the condition of a release, is charged with an offense committed during the defendant's release, or engages in conduct which results in obstruction of the orderly and expeditious progress of the trial or other proceeding, then the court may revoke and terminate the defendant's bond in order that the defendant be held without bail pending the trial or without release during trial. And this court's opinion, based on the proof that has been offered to me, we're very lucky that there's not a homicide involved in this case. I suppose one thing I could say is that we're lucky that there's such bad shots. 20 shots that were fired, and only 2 struck some sort of an object. Those shots may have been intended to be not strike an object, but the fact that one of those shots went through a trailer and lodged inside the dwelling place is of great concern to the court, because it could have struck and killed a child, it could have struck and killed an individual. In any event, the more important thing is that the proof before the court today is that this Mr. Ragsdale didn't learn his lesson from being arrested on those charges, and was aware of the fact that he had multiple aggravated assault charges pending, and still went into Thunder Alley, an area that serves alcohol on a regular basis, and demonstrated that he carried a weapon on his person. And the only reason to show that weapon was to threaten someone. And as a result of that, it is this court's opinion that the evidence has established that under 4011-141, his bond should be revoked. So I'll revoke his bond and order that he be held pending. I agree that he's a father. He should be working. He should be doing all of those things. He shouldn't be doing what he's charged with. Shouldn't be carrying a weapon around to a place like that and showing other individuals. And the proof so far, at least by the standard I'm required to on this hearing, is that he did in fact engage in that conduct. So this court revokes his bond and orders that he be. Does he have a trial date yet? All right. Then I will let you set it with Judge Wallace.
So trials can be with Judge Wallace. I'm not sure if he airs his trials.
All right. So this next court date is February 11th.
February 11th. With Judge Wallace. He's in custody.
We're going to take some other matters out of order in order to try to accommodate. There are some cases that will not be able to be live streamed, and there are some cases that there's not a problem. On Austin Wayne Carver, Mr. Yeager, we have reached all right, you're going to enter a plea on this one then? All right. You just need time to prepare it? All right.
We're gonna mute that for a second. That was an interesting hearing. Wow. Let's see. It's all caught up there. Let me see what we've got on camera 8. Okay, let me give you an update. Pringles, smoky cheddar, good to start out. They get worse the more you eat. By the end of it, it just tastes like salt. It's a 3.5 out of 10. Not recommended. Cheez-Its, smoked Gouda. Started out bland, but develops more. They get Gouda and Gouda as you go. Better and better flavor. Fan. I'd say 7 out of 10. And yet RA ate the whole thing. I was so hungry. I didn't have breakfast. I had Pringles for breakfast. That's what it was. All right. Let's see. I think we've got some more courts we can jump to. Cedric Simpson, obviously doing his thing. Let's try this one. Nope. 34th District. Well, that's not it. Let's go here. To 2.
That are being brought against you, the possible penalties, and your constitutional rights.
This is the mom.
While we've been trying to work out all of the
What just happened?
constitutional rights. While we've been trying to work out all of the
Oh, it stopped. It just quit right there. She's done. Let's see. Preliminary docket for Judge
Hearing
Webster.
in GW 2025 CR 122, State of Kansas versus Kent Hoover. Please announce appearances.
May it please the court, the state appears by Jill Gillette, County Attorney.
Your Honor, the defendant appears via Zoom, and Counsel Edward Batatory on his behalf appears by Zoom from a separate location.
Mr. Badatori, as we are set for preliminary hearing on count 1, possession of opiate, opium, narcotic, or certain stimulant, a level 5 drug felony, is your client still planning to proceed with preliminary hearing today?
Your Honor, after discussion with the county attorney this morning, I respectfully request the court put this over onto the misdemeanor plea docket. And we're working on resolving the matter.
I have a
super
secret
but
database.
I'm not real organized this morning. I don't know where I put it. But Jill and I talked. Do you remember the date that I said was good, Jill?
Judge, we were talking about 2/17.
2/17, Missy, does that look like a good time for a misdemeanor plea in this case?
$217. That was in the afternoon.
2/17 at 3:30. Yes, that would work.
All right, Mr. Hoover, I'm going to continue this preliminary hearing at your request to February 17th at 3:30. That is my misdemeanor plea docket. So I anticipate your plea agreement is to dismiss the felony and plead to the misdemeanor, or at least something out of that misdemeanor collection. I will continue the bond that you have previously posted on July 11 of 2025 for $12,500 through professional bonding. A condition added to that will be that you and Mr. Badatori reappear by Zoom February 17th at 3:30, ready to proceed. And of course, any prior conditions of the bond will be maintained as well.
Okay, we're going to cut to Thurston.
Anything further, Mr. Badatori, from the defense?
No, Your Honor, thank you.
Thurston just
You're
started.
welcome, Ms. Gillette from the state.
Not further from the state. Thank you.
All right.
All right, thank you then, Mr. Hoover.
We're going to Thurston County.
Mr. Stashevsky, good morning.
Good morning, Your Honor.
And I see Mr. Clark.
Yes, Your Honor.
Good morning. And you are?
My name is Sarah Fazio, Your Honor. Good to meet you.
Oh, okay, thank you. So, Mr. Stashevsky, I have several cases that are set for confirmation. So why don't we start with your cases?
Thank you, Your Honor. First, I can speak to Mr. Kelly Glazebrook's matter. Mr. Glazebrook is number 1 on the 9 a.m. calendar. Glazebrook, okay.
Right, Glazebrook?
Yes, Your Honor.
So this is on for confirmation, cause number 5A0094316. How are we proceeding?
Your Honor, the intention is to enter a resolution in this matter today. There should be a 12-month stipulated order of continuance in the judge's folder for one of the charges. I believe the state has a motion in regards to the other 2 matters.
See a stipulated order of continuance in court file. And currently the charges are resisting, obstructing, and assault 4. And this stipulated order is for 1 count of assault in the 4th degree. Who's handling this?
I am not.
And you said Ms. Facio, right?
Ms. Foster, yes.
This mic
Go
is
ahead.
terrible.
The state moves to, pursuant to this plea, dismiss the count of resisting arrest and the count of obstructing a law enforcement officer.
Okay, I'll grant that motion to dismiss those two counts and proceed with a stipulated order of continuance as assault in the fourth degree. Mr. Glazebrook, have you had a time to discuss your constitutional rights with Mr. Stashevsky?
Yes, I have, Your Honor.
By entering into this stipulated order, you are giving up certain constitutional rights, including the jury trial. In this case, it says that you'll be entering this continuance, allowing this, the county to continue this case to January 29, 27.
That is correct, Your Honor.
Under certain conditions, I'm going to find that you are entering this agreement knowingly, willingly, voluntarily, and intelligently. As such, I'll endorse this and sign up on this agreement. And best of luck.
Thank you, Your Honor. I appreciate it.
Wish you best of luck. Okay. Somebody asked how we find live court cases.
Anything else to add from this?
Basically, I have some great
Nothing
help.
from defense, Your Honor.
Okay, Josh, thank you very much. Let me see if I can find this. We've got one to pull up here really quickly. I've got to use this other one. Hold, please. We're going to 4 while I do this. All right. This just happened, Josh. Just a bit ago, he says, we're looking for, hang on. Do you know how long ago, Josh? I mean, I've got like half an hour to go through here. There's him. So that's 20. Let's start with him. Okay, here we go. Let's see what this is.
Well, if January 26th at 9:30 is good for you, then yes.
21, Judge.
Excuse me, January 21, that's what I got. For, that would be for another pre-trial.
Pre-trial?
Oh, but no, he's got to give you a notice first. So wait for him to come back after he copies it. He'll give you your notice date and then you can leave.
She's got a great mic.
Mm-hmm.
She could eat chips all day long, Red. This is Judge Sheila Johnson.
Oh,
Okay.
Looks like a Michigan court.
We got Jeremy Miller next.
yes, right.
This is case number. Should give you notice. Case number 26S00001 FY. People State of Michigan versus Jeremy Miller.
Morning, Your Honor. Courtney Rose, on behalf of the people.
Mhm.
I was on behalf of Jeremy Miller, big state and Jeremy Miller.
All right, and good morning. And
The
you're
next
here for a probable cause
next.
conference on carrying a concealed weapon. Maximum penalty on this is
10 years.
I think it's up to 5 years and a $2,500 fine. And forfeiture of the weapon might be in order there if you are found guilty of this. So you certainly have a right to have a preliminary examination. That would be within 21 days of your arraignment
Who's the
date
dude in the
and
Smurf
within
hat
7 days
sleeping
of
in
today's
court?
first probable cause conference. So you understand that. Okay. So how would you like to proceed?
We're going to skip ahead from this guy. This is the one we want right here.
February 2nd at 9:30.
All right, February 2nd, 2026, 9:30 for another probable cause conference. Bond is continued. Well, that takes care of that one. Mm-hmm.
Hey, let's keep an eye on this Dondre guy, Dondre Mays, who's working on doing the drywall on the ceiling.
We wait 21
Drywall's
days on that.
Oh, yeah, let's do
Drywall's
that
up.
too. Go back.
A little
I'm
bit
sorry.
tape and muddy.
I keep
Needs to be
forgetting
sanded
today.
though.
So, sir, you understand that you're going to be waiving your right to proceed within the 21 days of arraignment and 7 days of today's date so that your lawyer can get this deviation request in? Okay. All right. So that's the knowing voluntary waiver. Now we're all set for February 2nd.
Thank you.
All right.
Excuse me, Your Honor.
Who was talking to me?
That would be DeAndre Mays.
Okay. So, yes, Mr. Mays?
Sorry to interrupt you. I'm just trying to figure out when my case gonna get called because I've been in your court
Sir,
going since
do you,
8:30
well,
and I'm
we
about
got
to.
a lot of cases
I
here.
understand
I
that, man,
can't-
but I'm about to lose my job because I'm supposed
Okay,
to
well,
go
let's
back to work.
reschedule your hearing then. Let's reschedule.
Okay.
We
All
can
right.
do that for you because we don't want you to lose your job. And I'm going in order that they're giving me, and yours has not popped up yet.
I've been here since
it
8:30.
was
And it's
supposed to
almost
be-
12 o'clock.
Sir. Okay. Do you want to be heard or no?
I just want to be heard, but I can't keep waiting because I've been in here for almost 4 hours, Your Honor. 3.5 at the most.
Just told you that I would adjourn the case.
I'll take it.
Let me tell you, if you're asking me for some relief,
Yes,
you
ma'am.
have a little bit better attitude towards me because I don't like that. There's
Your
a way.
Honor, all
There's
due
a way
respect.
to listen. There's a way to address me, sir. And I'm
I
gonna
don't know which way to address you because
demand
even
that
when I had my
I'm
court
gonna
case
ask
before you over 10
listen,
years
sir,
ago.
I'm gonna be asking you to respect the court and talk in a manner that is respectful. And
I don't know what manner I'm not talking in
with that.
respectful.
I don't think there's anything wrong with asking for that.
And I don't think there's nothing I said that was disrespectful.
Yes, the attitude is not respectful.
Your Honor, all due respect. Let me try and change my approach to make this better. I've been in here since 8:30.
Okay, sir. We just
Can I finish, Your Honor? Can I?
No. Give him a date, please. I'm not gonna.
Yeah, please just give me a date. I'll come back.
Give him a date. And he was supposed to be next, so we'll just cancel it and give him a different
I'll
date.
just take the date.
Okay. Court's available January 28th at 10 a.m.
January 28th at 10 a.m.
Council is on. I don't know if she's.
You can just.
Yes, that's fine, Your Honor. I'm
Thank
sorry
you.
about that. January 28th at 10 a.m. We'll be here.
All righty.
Thank you.
Thank you, Your Honor.
There you go.
That's going to be choice.
Yep. This is case number 24S00101SM,
24
State
what?
of Michigan versus Mallory Walker.
Morning, Your Honor. Clerk, yours on behalf of the
Donald Law, 75 German 6 from Mallory Walker. Mr. Walker, you can state your name for the record, please.
Where's that on my docket?
He walks at a distinct
Here it is.
slow pace.
Okay, we're here for a probation violation hearing on a domestic violence. What is this? Oh, okay.
But my understanding is with my client that filed.
Yes, there was something. Talking about it's a motion for notice of special appearance under duress and reservation of rights, non-consent to commercial jurisdiction. Okay. So he's reserved some rights, whatever they are. That's fine.
The first thing I'd like to.
Then he has a motion to dismiss for lack of subject matter jurisdiction and failure to state a claim on which relief can be granted. Okay. Sir, we've had subject matter jurisdiction over you since this case first started back in 2024. So there's nothing different that has changed that would divest the court of jurisdiction at this point.
Maybe Ms. Rose now opposed her.
The attorney's like, can we talk real fast? What's this guy in blue? I mean, I love supporting your team, but he has like gone full Smurf mode in the courtroom. And he has his hat on. That's Cookie Monster. C is for cookie. It's good enough for me. Okay, I tried to fix the commands. Are they not working? Let me fix them again. Commands are not working. Okay, let's shut it down. First of all, we're going to try to turn it off and back on again, see if that fixes it. That usually does. We've got a pro se with a lawyer. Imagine one of those things has to go here soon. Okay, try it again.
Yes.
There we go. It's working. Fixed it. Just turned it off and on again. All right, so that's as far as we get. The judge passes the matter. Thanks, Josh, for the heads up. We would have waited here all day. Looks like the lawyer went and sat down. Like he's like, I'd like to withdraw, maybe. What do you think you'd have to do to get one of your essays on the board there in the back of the courtroom? Is that an accomplishment, or is this a wall of shame? What do you think? Weekends are not fun without RA entertainment. My weekends are great. I don't know what you're talking about. I would post the wall of shame variety. Here's not these are failed English essays. What not to do. All of them are AI, I imagine. You had to write lines about where which were the school rules. Oh man. Copy work was my least favorite thing to do. Part of the problem was when I was a young child, long story short, my brother broke my arm for me. I was ambidextrous, but I favored my right arm. And so I could write with both hands, and I could actually write with both hands at the same time. But it had to be the same thing. I couldn't like write two different. I wasn't that right lane, left brain, independent. But I could write the same thing with both hands at the same time. Then my brother broke my right arm for me. Sort of made the choice. Said you've got to choose. I chose left because my right arm was in a cast. But it sort of set me back a little bit, and I never really caught up all the way through school. My handwriting sucked. It was terrible. My signature was terrible, absolutely terrible, until I realized that my problem with my signature was I was trying to put all the letters in my name into my signature. As soon as you get over that hurdle where you realize you don't actually have to write your name as your signature, signatures become so much easier. You can just like whoosh, 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 walk across, dot, flash, and it's done. That's it. Now my handwriting looks great. Nobody can read it, but it looks fancy. Looks fancy. Yeah, copy work though. Oh my goodness. Like I remember when I was in school, did I mute her? No. I was in school when our computer typing class had a mixture of both typewriters, like tunk, 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 and, the keys like hitting the paper, and the newer typewriters, which actually had it had a little screen, and you'd type some letters, and then you'd hit space, and it would type it on. It was so you could edit, undo. So if you got one of the new computers, if you're early to class, you could fix your mistake before it got put on paper. Anyway, word processors. Oh man, cutting edge. The judge has muted and has not unmuted. The Smurf is back. I'm not sure what is that a Colts? Is he a Colts fan? It looked like it said 2008 on his hoodie, on his sweater, which might be the last year his team won. I don't know. I'm not a sports guy. Yay sports, go ball. That's what I do. What? El Teddy, or Lieutenant Eddie, as the case may be. RA has a heartbeat signature. You are a sports person, I can see by your profile pic. You got 3 whole teams up there. Let's jump around to find another court we can watch as I'm preparing to go to lunch, which I probably shouldn't do, honestly. Detroit Lions. So it was the last time they won, 2008, right? Am I remembering correctly on the Lions? Oh, that's a good song. Lady Gaga, Shallow, live. Where are my Lady Gaga fans at? All right. I don't know why it came up on my playlist while I'm looking for courts. What did I say that suddenly made my playlist, like right now, just turn into a music highlights reel? James Bond theme. Mark Rober. Good stuff, but not what I'm looking for. I have to go straight to lunch. It is about lunchtime, so Hillbilly Banjo Player in the Talent Show. It's probably also a good video. Back up to Thurston County for a minute. Let's see.
I'm sorry, what was the name again?
Jaime Lebano, I believe 9:30 calendar.
Got it. It's numbers 10 and 11 on the 9:30 calendar. County versus Jaime Lebano, Luevano, case number 5A0176194-5. It's on today for confirmation of trial on a driving while license suspended in 3rd degree and reckless driving. There's also a pre-FTC case ending in 3981. Ms. Myers.
Thank you, Your Honor. At this time, defense is ready to confirm for trial.
Mr. Libby.
State's ready to go. Thank you, Your Honor. Before we proceed, I do have a waiver to trial by jury. We would be requesting a bench trial. If I may file this with the court and approach.
You may bring it forward.
Okay, Josh says we have to go back to Judge Sheila. There's a case that's about with some heartfelt heart-to-heart discussion.
Trial date do we have in this case?
I believe it's January 21st and 22nd.
Pierce. You ready on McLean? Case number 25S01084SD. People State of Michigan versus Michael McLean.
Michael McLean, the musician?
Good afternoon, Kevin from Fair, on behalf of the Blaine was present with my side, sir, he's taking the Michael McLean.
All right, Mr. McLean, we're here for sentencing. And we weren't in receipt of a sentencing memorandum. I don't know if prosecutors saw it, and this is on one count.
We're going to go to lunch after this.
One count operated while intoxicated. So we do have a pre-sentence report. Did you have a chance to review it, and is it accurate?
Yes, I did have a chance to review that with my client, and it is factually accurate after a review. There was just one correction that I wanted to note.
All right.
Or it looked like there was going to be credit given for 1 day served, according to that assessment, and my client was arrested on August 23rd and eventually released from Southern custody on the 26th. So we've asked that.
4 days.
That's correct. And Allocution on behalf of my client, I did provide that sentencing memorandum to the prosecuting attorney as well as the court day following receipt of the pre-sentence report. I can be brief or thorough depending on if the court has had an opportunity to review on the voltage provider.
Actually, I have not looked at the sentencing memorandum. Looks like it came in yesterday.
Yeah, I had received the pre-sentence report on the 7th, and I wanted to get it to you as soon as I could, but that was instead of legal class.
Well, if you want me to try to peruse it now rather than adjourn it, I can do that.
I can barely hear him.
Or is it legal breath to actually be like.
Yeah, that's fine.
The client is 42 years old. He's single with no children. He resides with his parents in Livonia. He's working full-time at Watson's Home Leisure in Livonia. Sales and technology role where he's been employed for over 6 years. Prior to this incident, he had absolutely no prior criminal history. On bond in this matter, during the pendency of this matter, there have been no known bond violations. There was a significant accident in this matter. I don't want to avoid that issue, but the incident occurred on August 23rd. As stated, he was released from custody on the 26th. The following day, he was admitted into inpatient treatment at Henry Ford Brighton. The incident opened his eyes. He's openly admitted to me and confided in me that he is an alcoholic. He completed the inpatient treatment with no issues at Henry Ford Brighton. Following doing that, he did then, he was enrolled and admitted into a hybrid inpatient outpatient treatment program in Henry Ford Brighton, then completed an intensive outpatient treatment. He's currently enrolled in their early recovery group. While he was in inpatient and the hybrid inpatient outpatient, he was testing daily. Once he was.
How long was the inpatient?
The inpatient was, I believe, 16 days, John.
What was the name of the program?
Henry Ford Brighton Center for Recovery.
There's another place out there in Brighton, I thought. Might be the same place, I'm not sure, but okay, that's good. He went. All right.
And so he's completed all that. Once he was discharged from the hybrid inpatient outpatient, he started tracking his AA meeting yesterday. He had his 120th meeting. He does a sponsor in the memorandum. There is a letter from his sponsor. He also proactively started doing voluntary testing after completion at Henry Ford through Smart Start. He's been testing 3 times a day since October 24th.
Okay, that's good.
To date, there are no
violations.
missed test or positive test. His last date of consumption of alcohol was the date of this offense, August 23rd. He has plans to continue his recovery. He's working on his 4-step with his sponsor right now. I have had a chance to speak to him in detail about this offense. I do have a personal relationship with my son, so I've known him my whole life. He is my cousin. Man, for the city, I've seen the transformation that he has undertaken on his own board because he wants to have a better second half of life than he did previously. So
That's amazing the way you said second half. Yeah.
can't be honest with the board. That was his choice that I had told him. So give him that credit. And all I wanted to do, I know that the sentencing memorandum was perhaps a little over-inclusive, but he's the person who did the work. He knows that he brought himself before this court for his transactions. He has not run away from that. He's taking accountability for that. He's going to be better for that. And technically, there were no serious injuries in this matter. I just wanted to make sure that the court was aware of what he has been doing because honestly, I'm going to take what he's done, white out his name, and provide the clients in the future to say, hey, if you want to do everything that you can do to show the court you're taking this seriously, and get any substance abuse issues taken under control, this is the game plan that I would advise that you follow.
Well, you know what? I'm looking over all of this and, Mr. McLean, you're right when you use the phrase second half, because this is your first half of life and it's gone. It's already over. And it doesn't take long for that to happen. So you really, have to think about what you want to achieve during the second part of life. And will your second part of life be as long as you possibly can have it? And if you treat your body well, yes, it will be as long as it possibly can be before we all have to go that way.
just like to note for the record, for the court's knowledge, that the victims being defendant's parents are in the courtroom. I don't believe they wish to speak today.
Okay.
They were injured.
They were in the vehicle?
That's correct.
Wow.
Yeah. But, you know, the first part of your life, you started out well. You got parents, I mean, they're in the car with you. You could have killed them. And they're still here, supporting you, loving you, understanding you have a problem. But they gave you everything they could to start your life out well. Oh, you went to Catholic Central. Yeah, great. Great school. Got your bachelor's from University of Michigan.
UM?
It's the same amount of grades.
You what?
I'm just thinking of.
I don't care about Michigan State. No. Yeah, Michigan State's a great school too. You know, I didn't go to undergrad at either one of them. So my alma mater had green though, but it wasn't Michigan State. But I did go to U of M Law School, so I do have affinity for U of M. But you know, it's a great education to start you off to be the best you could be. Did you start drinking in high school or college? Which one? College? High school. Yeah. It happens. And when you look back on those choices, you see how it really affects. And when you're drinking, you're not thinking. First of all, you're drinking illegally in high school, but nobody seems to think about that part. But they should be thinking about how is this affecting me, but they don't. You're young. So you don't realize that you're setting a stage for addiction. Then you get to college and it just continues because it's everywhere. Beer used to be, I used to say, I'm not sure if it's changed, but it was the number one substance I would see in drunk driving cases. Beer, not hard liquor or mixed drinks, not wine, it was beer. And that's because people seem to think beer is like not really intoxicating for some reason. And people go out there having a great time in the summertime, they've done some sports, they want to grab a beer. No, that's grabbing alcohol to dehydrate you, not drinking water or Gatorade or something.
Scotch's mom, that's just
So
the
people get
sentencing.
into this habit of thinking beer is just not intoxicating. And I have a statistic, and I don't have my paper with me, but I did look it up online, and it's there still, that when you're looking at a shot of vodka and a 5-ounce bottle of beer, which one has more alcohol?
Same.
They are. So that means that if I told you you drank 6 shots of vodka, you would say, oh, yeah, I could probably get drunk on that, wouldn't you? But you weren't thinking about 6 bottles of beer. And that's the difference. It's just equally as intoxicating. And so you got yourself into a little problem. And it took this to wake you up. And I always say, if something bad happens, it's okay as long as you learn something from it. And nobody got hurt or killed. You just messed up some property badly, your car and whatever else you hit. So this is now, she's going to tell me what you did hit what.
Well, my understanding of the injuries were that his mother's ribs were broken.
Oh, so she did get injured, but not deathly injured, but seriously injured.
Yes. She
that could have punctured her lung or anything.
Yes, it was a serious accident that fortunately was more serious.
It said here massive, and the pre-sentence report, it just said there was massive debris in the roadway. So unfortunately that happened, but fortunately she's here. She's hopefully doing well and still supportive of you.
Man, you
So,
break a rib and it just hurts.
This
to
is the
breathe.
kind of thing that really changes a life. And hopefully yours is changed forever. Because now you don't go around those folks you hung around with. You don't celebrate the same way. You don't deal with adversity by drinking. You value the life that you've been given and the lives of your family. And you stay supported. This is a lifetime journey. You just at the beginning of it. So that means you got to stay in the AA. You got to keep your sponsor. Even if you become a sponsor down the road, keep your sponsor. Yeah, well, if you want to be, you will. You will be. Because the people like you are dependent on them. People who managed to get this under control. I can't say you're ever cured, but you can get it under control and you can be in this remission as long as you focus on it. And don't let it focus on you. One day. That's all you can do. Just
day at a time.
Pray for the next day and be thankful when it comes that you didn't drink at the end of that day. That's all you can do. You know, I love the memo. I perused it a little bit. You seem to have done just about everything you could do to get it under control. And so now the court's job is to make sure we monitor you and that you keep it under control.
Testing 3 times a day
And
is good.
a very nice memo, Mr. McClung. Very nice. Okay, so what do you want to tell me?
No, there wasn't no contest. We have advised my client that I prefer that his actions and what he's done speak for him. So I can actually not.
All right, is there a potential civil liability in each? Okay, I understand that. Parents don't want to speak. Do you wish to say something?
I believe I've already informed the court to the extent necessary, given the parents' presence here. If they had anything to add, I'm sure they would come up and tell the court, but I spoke with the defendant's mother and she indicated that they don't wish to say anything on the advice of defendant's counsel, which to me indicates that they are asking the court for understanding and leniency.
Okay. Well, it's his first alcohol-related offense. Might not be your first time drunk driving, but it's your first offense that you got caught. So, typically, I would order rehabilitative services, many of the things you've already started or completed, and some of the things that you're still continuing to do. Because the goal here is not only punishment, but rehabilitation. The recommendation is fair. I'm surprised they didn't even say 18 months rather than 24, but that might be because it's not as high of a BAC as they probably thought it could have been, but it's high, the 0.14.
Almost double.
I'm willing to adopt this under the circumstances. I think it's a fair recommendation. I think you've stepped up to the plate. I think you've learned a lot. And I don't think you're going to let your guard down again against alcohol. You just can't.
I just have one question as far as adopting probation's recommendation. There was an outpatient substance abuse treatment relapse prevention program. Would the court be fine with him continuing with the early recovery group that he's currently reading about? He's done inpatient, outpatient, a hybrid program.
Well, what he would have to do is show them that he's completed the outpatient. So I think they said even in the report, bring it.
Yeah.
Just send it to
What I have, part of the reason that I provided the sentence amendment, and then what I'm going to tell my client is to bring a copy of this within to probation for his first meeting so that they for sure have all of the information.
Right.
What he has to do.
And they might need to verify that with the counselor.
And all the contact information about those emails.
All right. So the sentence of the court would be for a term of 18 months of probation, $720 of probation oversight fees. Of course, he could be released early if he's benefited and would like to try to be released. He'd have to fill out the form and ask probation for that form. Say why you want to be released early, and it has to be at least 1/2 of the time frame has had to have elapsed. Probation will weigh in on it. Tell me what your level of compliance has been, send it to the prosecutor, and then send it back to me. And if no one has any objection, we would likely just release you on paper with no hearing. If there's objections, we'd set it for a hearing. So the fines and costs are $700. The jail time is going to be 7 days with credit for 3. 7 days with credit for 4.
So he has to serve 3 more, or are they suspended?
And then the 3 days would be in the impact weekend.
So he can be out during the weekend, serving the weekend?
All right.
Thanks, Your Honor.
He'll do some community service too. They have him do 2 days community service, attend the victim impact panel, do the outpatient, which he's already done. Just bring proof of that.
All right.
Outpatient substance abuse treatment.
Angel
and
Watcher,
relapse
welcome.
Prevention.
It's good to have you here. Thanks for the subscription.
I don't have any objection to it being wherever he's already enrolled. Of course, no alcohol or unprescribed drugs. There will be testing. How many AA meetings were you doing? Per week.
Continue those. All right, we're going to, as he gets his sentence
So I'm going to say right now, you have to at least do 5 days a week.
5 days a week AA.
Continue on your path with the 7.
3 times
though.
testing.
But if it gets to a point that they say, or you feel with your sponsor, you can reduce it, then go down to the 5.
All right. We're going to mute her for the rest of that. It's time for lunch. It's time for lunch. We're going to be back. We've actually already got the portal set up. You can just stay right here. Grab the hand of a portal buddy and jump through. Face the light. It doesn't hurt. You'll be there in no time whatsoever. We'll be back this afternoon for a little more court watching. This is our last, I think our last day of court hopping before we pick up a new trial. So we've got some big trials coming up early next week. One starts on Tuesday. One might start on Monday. We'll hopefully be there for that. We're not doing the Uvalde. That's a choice I made. I just don't want to hear evidence of a bunch of kids hurt. Tonight when you go home, please hug the people you love. Smile at someone to make their day just a little bit better. And please stay safe till we go live again in about an hour from right now. So we'll see you in a little bit. Have a good lunch.